Good morning. The Senate Judiciary and Public Safety Committee will come to order. Today is Thursday, March 23, 2023, and we do have a quorum present. We have 3 bills on the agenda today. We do have identified testifiers for each of them. There was an opportunity on the Judiciary Committee website to sign up in advance to testify. Because we had a lot of people interested in testifying, we are not going to be able to just open the floor for people who are present to come and add their voices at the table. We will stick to the list of those who signed up ahead of time to testify. Because of the number of people that want to participate again, we are going to ask our testifiers to limit their testimony to 2 minutes each. We will be timing it, and so staff will respectfully remind you it's time to wrap up if you go past 2 minutes. That way we will have ample opportunity for everyone who did sign up to share their views on the bills, and then leave ample opportunity for the committee to ask questions and to discuss the bills before us. We're going to ask everyone to please be respectful of each other and of the testifiers. So if someone says something that you vehemently disagree with, please keep your vehement disagreement internal. We're not going to, I expect everyone will be respectful, won't be yelling, screaming, hollering, making comments, calling people names or anything like that. I respect that this is a passionate issue for a lot of people on both sides of that. So we want to make sure the decorum is appropriate as we consider the policy that is before us today. Because I am the chief author on the 3 bills before us, I'm going to turn the gavel over to the committee vice chair, Senator Claire Umu-Verbaeten, to conduct the hearing. Senator Umu-Verbaeten.
We'll begin with Senate File 1116. Senator Latz, when you're ready.
Madam Chair, for those who have followed the committee for many years, you may recall, at least I was told, I became known because I carried a can of Mountain Dew with me to all of our meetings. I've switched to Fresca for the record, so everyone's probably better off for that. Madam Chair, members of the committee and members of the public that are watching and participating in this process, gun violence is an epidemic in our society. We know that because for some it's a regular occurrence in our neighborhoods. For others, it's a regular appearance on the evening news or to update the technology on our news feeds on our cell phones. Gun violence destroys lives, ends lives, destroys families, traumatizes communities, and has people often living in fear. We will have a number of proposals over the course of the next week. We've already heard some in this committee, aiming to reduce violent crime in our communities. Gun violence isn't only crime. Gun violence includes suicides. And in fact, in Minnesota, there are more deaths from suicide by firearm than there are deaths from homicide by firearm. And that is a statewide phenomenon. In fact, the suicide death is more prominent in greater Minnesota than in the metro area. We have laws on the books that reflect the efforts of the state of Minnesota and our society to prohibit or prevent people who are not lawfully eligible to possess firearms from possessing them. We also have extensive community efforts to identify those who are at risk of either perpetrating a crime or of self-harm. Probably everyone in this room will agree that given the current epidemic of violence, those laws have not proven to be adequate to the task. What we will hear today are 3 proposals to step up to the plate a little bit more and try to prevent firearm tragedies. These proposals are fashioned in a way, intentionally, to respect the right of lawful persons to possess their firearms in accordance with the Second Amendment, and also to find a way to separate firearms from people who are not lawfully in possession of them, or who pose a substantial threat to themselves or others by that possession. These bills are not intended to infringe on any constitutional rights. The United States Supreme Court, even in the cases that recognized the expanded interpretation of the Second Amendment, simultaneously and even in that decision recognized that there are lawful regulations that communities can enact within that constitutional right. Regulations to who can get access to guns and how they may get them. The first bill before us today expands criminal background checks for the purpose of screening out the people who want to possess firearms to get firearms, but who are not eligible under the law to possess those firearms. Most of what the bill does is provide a process by which those background checks can be accomplished. Currently, somewhere around 60% of firearms transfers, and when I say firearms in this particular case, I'm referring to pistols and SAMSAWs, or semi-automatic military-style assault weapons. I am not referring to long guns such as hunting rifles or shotguns. Those are not covered by existing law in this regard, and I'm not proposing to expand to cover those. So pistols and SAMSAWs. Currently, somewhere around 60% or so of the transfers of pistols and SAMSAWs go through federally licensed firearms dealers, where there is a background check and waiting period under federal law as well as under state law to determine if the person who wants to purchase the firearm is lawful to complete that purchase. However, that means somewhere around 40% of these transfers are occurring outside of the FFL system. They're not being subjected to background checks. So they're happening at gun shows where they have a mix of FFLs and non-FFL sellers of firearms. They're happening online. They're happening between neighbors or friends. The bill before us proposes to close those loopholes while still leaving a path for transfer of firearms between family and household members without going through a background check. There are also actually a number of other exceptions under the law, statutory exceptions that we are not proposing to change. The mechanism of the background check in this bill is to utilize the existing statutory permit to purchase or transferee permit process that's in Minnesota. Under the current statute, a person can apply for a permit to purchase. They can also apply for a permit to carry, which routes them through the same background check screening process. A useful metaphor for this screening process would be if you went to an airport and you want to get on an airplane, and 60% of the people were told they have to go through the security metal detector and so on, and the other 40% of the people were just routed around it, allowed to pass through without any screening. That's what we have in Minnesota right now. The existing statute is a known process, but we are making some changes to it. And we are ramping up the penalties for avoiding going through the background check process. So here are the main features of the process. A person who wishes to lawfully purchase a firearm, meaning a pistol or a Samsung in Minnesota, would be able to apply through their local law enforcement agency for a permit to purchase or a transferee permit. I'm going to use the term transferee permit because that is what is technically in the statute. They have an obligation to declare certain information. Right now, it's a gross misdemeanor penalty to lie on that application. Under the bill, it would become a felony to lie on that application. Law enforcement agency would then have 30 days, which is longer than the current statutory 5 days. They would have 30 days to do the background check. That background check would cover everything that they ordinarily do on background checks. They'll check on the federal databases. They'll check on the state databases. They'll determine if a person is eligible. That eligibility determination will be a combination of existing law. So, for example, if an applicant has a qualified domestic violence conviction, if they have other qualified crimes of violence convictions, if they have certain Chapter 152 drug-related convictions, and any number of other existing statutory prohibitions, and they are ineligible under state law to possess a firearm, and the application would be denied. There are also certain prohibitions under federal law that would also cause a denial. There are a couple of additional provisions in this background check that could also lead to a denial that we propose to add to statute. One is if a person is in an existing gang database. Now, for those who get denied for that reason and believe it was a wrongful denial, that they should not have been in the database, or they were in the database for some wrongful purposes, there is a spelled-out appeals process to enable that follow-up to be done. So there's an added due process in that regard. Another criteria that's being added to the statute for denial is if law enforcement believes that a person would be a danger to themselves or to others in the community. There is also a clearly spelled out process to challenge any denial under that provision within the law enforcement agency and then externally through the court process, and defined time limits for decisions, with the burden being on law enforcement to establish by clear and convincing evidence the grounds for the denial. If a person is denied and the application, and they remain denied after any challenges to it, then they would have opportunities down the road to reapply. And certainly if circumstances change, they'd have that right to do it. There would be no charge for an applicant. The standards here are intended to expand the due process available to those who are denied applications, also to give law enforcement the necessary tools to find and determine and thereby screen out those who cannot lawfully possess firearms in Minnesota. If a person gets a transferee permit, there are no limitations on how many firearms they can purchase under that permit. Some of you may recall earlier versions of this bill that required a permit for each proposed purchase, or limited the number of permits, or limited the time in a very short time. Those limitations are not in this bill. The permit would be valid for a year. And the permit could be used for an unlimited number of purchases during that period of time. This actually will streamline the process, not only for law enforcement, but also for applicants and purchasers. If during that period of time while the permit is valid, it comes to the attention of law enforcement, either from any variety of sources, including from the courts, that a transferee permit holder is no longer eligible to possess the firearm, then the issuer of the permit, the law enforcement agency, will be revoking that permit. We'll notify the individual the permit is to be revoked, and the permit itself should be turned in to the law enforcement agency. If a person has a lawful permit, they can go purchase the firearms. With that permit, there is no additional waiting period from the time of purchase to the time of transfer. In other words, they can present the permit to the seller, pay the cost of the transfer, and can be handed the firearm immediately. There's one caveat to that. If the seller knows that the proposed purchaser really is not eligible to possess the firearm, they're not allowed to go ahead with the transfer. And they will need to keep a record of the transfer for a period of 10 years. Upon criminal penalty, if they don't keep it, so that if a firearm ends up being used in a crime, law enforcement has the ability to trace the provenance of that firearm to try to determine if the laws were complied with in terms of the transferee permit. That's the basic outline of the bill, members. I do have an A3 amendment which will be an author's amendment, as this is the first committee stop for this bill. It is a delete everything amendment, which contains the content of what I have just gone through. I'm happy to answer any questions about details, and I understand council has some changes to make to the A3 amendment before we ask the committee to vote on it. So, Madam Chair, I'd like to put the bill in the shape that reflects the description I've given it, and then I welcome the testimony of the public.
Yes, thank you, Senator Latz. We'll go to council. Mr. Backus.
Thank you, Madam Chair and members. The changes are on page 6 of the A3. On line 6.23 and 6.26 and 6.29, delete the new language and reinstate the stricken language. And then on line 6.31, delete firearms and insert a pistol or semi-automatic military-style assault weapon.
Yes, Mr. Backus, could you repeat that one more time?
Yes, Madam Chair. On page 6, line 6.23, 6.26, and 6.29, reinstate the stricken language and delete the new language. And then on line 6.31, delete firearms and insert a pistol or semi-automatic military-style assault weapon.
Thank you. Senator Latz moves the A3 amendment with the oral amendment as described by council. This is an author's amendment. All those in favor say aye. Aye. Opposed? Okay, the amendment is adopted. Senator Latz, would you like to move on to testifiers?
Yes, Madam Chair.
Okay. I'll invite the first two testifiers to come forward, Commissioner Bob Jacobson and Chief Jay Henthorn. And I'll remind you that you have 2 minutes. We'll be timing you.
Madam Chair,
Yes, Senator Latz.
while our witnesses are approaching, I would like to just note with appreciation the co-authors on this bill, Senators Westland, Dietzick, and Marty. And note also on the background check bill, we have a strong law enforcement support, as you will hear, but the Minnesota County Attorneys Association, Minnesota Chiefs of Police Association, the Minnesota Sheriff's Association, and the Minnesota Police and Peace Officers Association, which represents rank and file officers, all support this bill.
Thank you. Commissioner Jacobson, when you begin, please state your name and title for the record.
Thank you, Madam Chair. My name is Bob Jacobson. I'm the Commissioner of the Department of Public Safety. I'm here today to support Senator Latz's Senate File 1116, which would require criminal background checks on all private transfers and sales of firearms. While I'm new to the Department of Public Safety, I know that the Waltz administration has been pushing for this change for over 4 years. Requiring criminal background checks on transfers of firearms is a common sense law that will help keep firearms out of the hands of criminals. In fact, 21 other states have adopted a law to accomplish this very same goal. Currently in Minnesota, to purchase any firearm at a federally licensed firearms dealer, the buyer must pass a criminal background check. This bill would help ensure that all gun purchase and transfers are treated that same way. Now, this bill will not stop every criminal from acquiring a firearm, but I do believe, and statistics from other states have shown, that it can help cut down on gun violence. We will still need strong prevention, intervention, and enforcement to reduce gun violence in our state, and local law enforcement and other community groups are critical partners in that work. The Police Executive Research Forum put out a publication on reducing gun violence. One of those 9 recommendations was to keep guns out of the hands of people who are prohibited from owning them. This includes requiring background checks on all private sales and transfers. That report also shows that the National Instant Criminal Background Check System has prevented more than 1.5 million illegal firearm sales. This proposal has the ability to reduce gun violence and in return reduce the number of victims of violent crimes. And as the new commissioner of the Department of Public Safety, I commonly think about how to best serve the mission of the agency, which is serving all communities to build a safer Minnesota. I think this proposal helps us do that, and we are in support. Thank you, Madam Chair.
Thank you, Commissioner Jacobson. I'll ask you to vacate the testifier table and invite our Ramsey County Attorney, John Choi. And Chief Henthorn, you may begin. Please state your name and title for the record.
Thank you, Madam Chair, members of the committee. My name is Jay Henthorn. I'm the Chief of Police for the City of Richfield. I'm here today speaking on behalf of the Minnesota Chiefs of Police Association, who represent more than 300 police chiefs across the state of Minnesota and 200 command staff members working in those departments across the state. I am here this morning to testify in support of Senate File 1116. The Minnesota Chiefs of Police Association, along with many Minnesotans, support criminal background check legislation. While we know this won't prevent all gun violence or gun deaths, we do think it will make a difference. Current law here in Minnesota has a loophole that allows handgun and semi-automatic military assault rifle sales at gun shows, private transactions, and online purchases to happen without a background check, while other sales do require background checks. We feel strongly that requiring a criminal background check on all sales and transfers will prevent at least some firearms from going to individuals who are not legally allowed to possess them. We want to thank Senator Latz and co-authors of this bill for their continued support and hard work on this important public safety issue that will have a dramatic impact on our state. Thank you for allowing me to testify here this morning.
Thank you, Chief Henthorn. I'll ask you to vacate the table and invite up Dr. Laurel Reese, if I'm pronouncing your last name correctly, and Attorney Choi. You may begin. State your name and title for the record.
Thank you, Madam Chair. My name is John Choi, and I am the Ramsey County Attorney, and I'm here today on behalf of the Minnesota County Attorneys Association, which is the association that represents all of the county attorneys, the 87 county attorneys in the state of Minnesota. And we are of very different backgrounds. Our county attorneys represent, and we're elected by rural constituents, suburban constituents, and urban constituents, and we are also from different parts and backgrounds. But for a long time, we have come together to support expanded criminal background checks for transfers of firearms. And I want to thank Senator Latz for his advocacy to bring this bill forward again. I think that this is not going to be the solution to end all gun violence, but we as county attorneys believe that this is a critical piece as a part of the solution. And we've had this conversation for way too long. The bill that is before you, I think, is a very reasonable proposal to really close an important loophole that exists. And we think that if we can do that, we will have better outcomes for our public around public safety. And again, this bill isn't going to solve all of the issues that we have with gun violence in our state. But I do believe what you just heard from Commissioner Jacobson about making sure that we have all of the solutions on the table and we're all pulling together, I think, is a really critical piece. The prevention, the intervention, and the enforcement. And this part of it, I think for too long there's been this loophole that people are going to be talking about throughout the testimony. So members of the committee, I urge you on behalf of the Minnesota County Attorneys Association to support this bill. Thank you so much.
Thank you, County Attorney Choi. I will invite Dick Davis up to the testifier table. And Dr. Laurel Reese, you may begin.
Thank you, Madam Chair and committee. We understand the mispronunciation of last names together here, I'm sure. I live in Falcon Heights, and I'm a family physician practicing in St. Paul. And I'm here representing the Minnesota Medical Association and our 10,000 physician members, as well as the Minnesota Academy of Family Physicians and their 3,100 members. Firearm death and injury are an epidemic, and it's especially important that you know that this is an epidemic that affects children. Firearms have recently become the #1 cause of death in children in the United States. So it's not cancer, it's not drowning, it's not car accidents. Firearms are the #1 thing that kills American children. We also see that firearm violence disproportionately affects our communities of color, with African Americans experiencing 18 times the firearm injuries that other people do in our community. While our current system has been successful at preventing individuals who are prohibited from purchasing guns in the tens of thousands, our loopholes must be closed. I'm confident that people will say that this will not stop all firearm death and injury, but just because we can't do everything doesn't mean we shouldn't do what we can. A few years ago, physicians were scolded for our advocacy on behalf of firearm safety, stating that we should stay in our lane. Members, this is very much our lane. Not only do physicians work to repair tissue and organ damage, but we're the ones who are responsible for telling family members that their loved one has died, their child, their parent, their friend. This is a public health epidemic. How many preventable deaths does it take to make a measure important? This is important in protecting the health of our community. On behalf of Minnesota's physicians, I urge you to support this smart, common sense measure. Thank you.
Thank you for your testimony. And I'll invite Thea Williams up to the table. Dick Davis, please state your name and title as you begin your testimony.
Madam Chair and committee members, I'm Richard Davis, here on behalf of Giffords Gun Owners for Safety in support of Senate File 1116, which would require all firearm transfers in Minnesota to be subject to a background check. Background checks are the most important tool we currently have to enforce the laws already in the books. We have procedures in place to prohibit access to guns by people who are at higher risk of committing violence, including those convicted of felonies and domestic abuse, but they only apply when guns are purchased through federal firearms licensed dealers. Those same individuals can buy a gun through a private sale with no questions asked. That's the current state of our law right now, and it's unacceptable. Background checks are extremely popular with Minnesotans, including gun owners like me. They're just common sense. You'll likely hear people testify today that background checks won't stop criminals from getting guns and will only burden law-abiding gun owners, or that transfers from unlicensed sellers are usually the people they know, so we don't need background checks on private sales. Not only are these people wrong on the facts, they represent the most extreme views on guns. Most people do indeed want their state lawmakers to pass this basic common sense law to keep guns out of the hands of people who are not allowed to have them. As a Minnesota gun owner, I strongly urge you to pass Senate File 1116 out of committee. It does not infringe on my rights and is a critical step towards gun violence prevention. Thank you.
Thank you for your testimony. Rolf Olson, you can come forward. And Ms. Thea Williams, if you could state your full name and title as you begin your testimony.
Madam Chair, member, and members of the committee. My name is Thea Williams, and I am a community outreach and training supervisor for the Next Step training, for the Next Steps program. Located at Hennepin Healthcare, North Memorial, and Abbott Northwest, Children's, Minnesota. The Next Step program is a hospital-based program that offers trauma response and recovery services to support survivors of gun violence, many of whom are in communities of color. Since 2016, we have served over 1,000 participants. We are available 24 hours a day for survivors, and when families arrive to the hospital in deep grief, shock, anger, and confusion from the senseless death of their loved ones due to gun violence, support from our program comes in whatever form they may need. Being a non-judgmental listener, we have sat in hospital rooms in the middle of the night with patients who are alone and scared. They can't sleep while they replay in their minds what happened to them. We offer group meetings for survivors to strengthen bonds between individuals, to humanize each other, and to see each other in a different light. We connect survivors to housing or jobs when their own may have been lost or they can't go back to the community where they were injured. And sometimes, the most difficult of all, we help with funeral expenses for families who can't afford them. We have bought coffins for 10 children killed by guns. The Next Step program exists to interrupt the cycle of violence. Hurt people tend to hurt people, and violence leads to violence, but we can interrupt violence by helping to heal families harmed by guns. There is only so much we can do. We need you, our elected officials. You use your position to be violence disruptors with us. We need your help to limit access to guns for people who are not thinking rationally or who are ineligible to have them. No proposal fixes everything. There is much to do to fully stop this crisis, but these proposals today will save lives. This will protect more families and excuse me, I'm sorry.
And Ms.
More-
Williams, if you could wrap up your testimony.
Okay. So I just want to say thank you for the opportunity to speak, and we just don't want to buy any more coffins for children. Thank you.
Thank you, Ms. Williams. Pastor Olson, if you could state your full name and title as you begin your testimony.
Madam Chair, members of the committee, my name is Rolf Olson, and I'm a volunteer with Protect Minnesota. I'm a husband, I'm a grandfather, I'm a Lutheran pastor, I'm the father of a murdered daughter. In October 2007, our daughter Catherine went to a house in Savage to answer a Craigslist ad for a babysitter. What she encountered was not a woman needing childcare. She encountered a 19-year-old man with his father's pistol. It was over in 5 minutes. Catherine arrived with a backpack full of children's toys and books. She did part-time work as a nanny to help finance her path toward a graduate degree in Spanish. She loved kids, they loved her. This trip to Savage was nothing new, except it was her last. Catherine was brilliant, creative, adventurous, curious. Her dream was to put together her love of Spanish and theater for a career. But that dream ended with a bullet in her back. As a gun owner and outdoorsman myself, I'm not opposed to guns, but I know how deadly they are. And I know that what we are doing now is producing unacceptable results. I know the argument of the gun lobby that claims that any legislation will only punish law-abiding citizens. They claim that the inconvenience of a background check is unconstitutional and will have little impact. Well, try telling that to families of loved ones lost to gun violence. Consider how they were inconvenienced. Consider how my daughter was permanently inconvenienced by being put in a grave. I don't understand the morality of someone who pits the occasional inconvenience of a background check against the permanent consequence of a firearm that gets into the wrong hands. Well, the facts are clear. States with the strictest gun laws have the lowest rates of gun violence. Background checks are simply part of a comprehensive plan for public safety. There's nothing in Senate File 1116 that hinders the ownership and safe use of a firearm. It's a goal that every true sportsman supports.
Please wrap up your testimony, Pastor Olson.
Thank you for using your wisdom to help prevent further carnage in our state.
Thank you, and I just want to also say I'm so sorry for your loss. Next, we'll hear from Ramya Swamy. Please correct me on the pronunciation of your name. You're joining us virtually. You can unmute, state your full name and title as you begin your testimony.
Thank you, Madam Chair and members of the committee. My name is Ramya Swamy, and I'm the State Policy Manager for Brady, an organization that unites gun owners and non-gun owners alike to take action against gun violence. Today, I'm here to speak in support of SF 1116, Background checks alone won't end gun violence, but it is impossible for any gun law to function without the foundation of a background check. A firearm is a firearm, whether it comes from a federally licensed firearms dealer or a private party, yet current Minnesotan law treats firearms sold by FFLs different than those sold by private parties. This bill will change that. The Second Amendment is no barrier to the proposed universal background check bill because the licensing requirement at the heart of the bill uses the sort of objective criteria that the Supreme Court endorsed in Bruin. In Bruin, the Supreme Court invalidated a New York law that required individuals seeking an unrestricted concealed carry permit to show proper cause. In part, the court invalidated the law on the basis that states cannot issue concealed carry licenses based on subjective criteria. In contrast, the court suggested that objective criteria are permissible. Given that the proposed universal background check bill here requires individuals seeking to obtain any firearm, whether from a private seller or an FFL, to have a transferee permit, and Minnesota grants those permits on an objective shall issue basis, the proposed bill accords with the Bruin standard. Indeed, none of the post-Bruin challenges have overturned or challenged the constitutionality of background checks, and for good reason. The Bruin court said that gun laws that accord with the Second Amendment's text and historical understanding would be constitutional. Public safety concerns and dangerousness have always been the justification for firearms laws, whether in the 1700s or today. Background checks like those proposed here follow in this tradition, and for the reasons stated above, I urge you to pass this bill. Thank you.
Thank you, Ms. Swamy. I'll invite our next two testifiers up to the table, Brian Ghosh and Carl Kaufman. Brian Ghosh, when you're ready, please state your full name and title as you begin your testimony.
Good morning, Madam Chair, members of the Senate Judiciary Committee. My name is Brian Ghosh. I'm a lawyer and registered lobbyist with the National Rifle Association, opposing Senate File 1116. This sets up new ways law enforcement can deny a transferee permit. It essentially kind of incorporates a red flag standard into that process without sufficient due process. And that denial is good for 6 months. It can be denied again and again and again in perpetuity. It makes it difficult to loan a firearm to many types of relatives. So the bill excludes cousins, aunts, uncles, nieces, and nephews from those loans. Minnesota's got a strong tradition of hunting, and this bill would set up an owner's process for loaning firearms for that purpose. House file, or Senate file 1116 also adds a requirement for recording serial numbers and firearm identification information upon each transfer. It sort of then indirectly sets up a form of government firearm registration. Additionally, it sets up unreasonable requirements for retention of paperwork, 20 years under this provision, and unreasonable criminal penalties for violations. In this region, Minnesota is unique that it requires a permit to purchase. The neighboring states don't require that. And then in this case, not only are you saying you should have a permit to purchase, which the neighboring states don't have, you're saying the law enforcement can deny an application up to 30 days. It take 30 days to get a permit to purchase, compared to the current law, which is 7 days. Now imagine an abused partner going in to purchase a pistol, finding out that they can't buy a pistol for self-defense purposes when they need it right now, that night perhaps, because they have to have a permit to purchase. Or in this case, have to wait up to 30 days before they can get that permit to purchase and then purchase that pistol. So for these reasons and others, we would oppose this Senate file.
Thank you for your testimony. I'll invite Ben Dorr up to the table in your spot, and Carl Kaufman, if you can begin, state your full name and title.
Thank you. Madam Chair and members, my name is Carl Kaufman. I'm here on behalf of the NRA. I've been a lifelong member of the NRA, a husband, a father, a grandfather, a very active hunter and shooter in outstate Minnesota. I live in Spicer, Minnesota. I'm here today to state my opposition to SF 1116 with regards to transfers and background checks. My opposition is mostly that this is an infringement upon the Second Amendment. Second Amendment is paramount to our Constitution, as you all know. This would place a lot of gun owners in a position to register their guns via the background check. And this is an infringement upon our Constitution. There are 41 gun laws in Minnesota today. There are only 10 states in the United States that have more gun laws than Minnesota right now. This will make hardworking, honest Minnesotans, tax-paying, family, hunting, shooting, firearm collecting hobbyists, criminals, with registering a lot of these weapons. The sale of firearms is substantiated by 4473, the federal form. I don't know if you've all seen the federal form, but it is a substantial questionnaire on ownership. I would encourage you all to review this substantial document. I filled it out a few times in my career. What we need to do, we need to enforce the laws that we have. Enforcement is paramount to any of the judicial system.
Mr. Kaufman, please wrap up your testimony.
Can I finish my sentence?
Yes.
Thank you. We need to prosecute and sentence accordingly. We cannot plea bargain things out. Thank you very much for the opportunity to speak here today.
Thank you. James Anderson, you may come forward. And Ben Dorr, if you could state your full name and title as you begin your testimony.
Of course. Madam Chairwoman, members of the committee, my name is Ben Dorr. I am the Executive Director for Minnesota Gun Rights. Don't have much time, so I'll just go quick so I can't begin to tell you how opposed to this bill the members of Minnesota Gun Rights are. I suppose I could list out a bunch of statistics and tell you how this state is safer than that state because of this or that law. I could explain how universal background checks haven't saved a single life or lessened crime in any state they've been passed in. I could talk about how the Parkland, Florida shooter, the Sutherland Springs church shooter, the Las Vegas shooter, Orlando nightclub shooter, Charleston, South Carolina church shooter, the Chattanooga recruitment station shooter, the Fort Hood shooter, the second Fort Hood shooter, the San Bernardino shooter, the Aurora, Colorado shooter, Newtown, Connecticut, and Gabby Giffords shooter, and on it goes, all passed background checks or completely circumvented the background check system before using a firearm to go on a killing spree. Or I could explain how this bill is an absolute slap in the face of law-abiding gun owners and an unforgivable undermining of our constitutional right to keep and bear arms. But I won't, because these hearings and this bill is an absolute sham. The chairman and the DFL have made it very clear that they want to strip us of our foundational rights, regardless of any opposing testimony. So all anyone can conclude from this is that this whole committee hearing is a dog and pony show put on for the anti-gun left. So I'll just leave it with this. The members and supporters of Minnesota gun rights are extremely unforgiving, and we have very long memories. Any legislator, especially the ones in weak districts, will face the full political fury of mobilized gun owners in their districts at election time if they support this bill or any similar legislation in any way. Minnesota gun rights will make sure of that, as we have for the last decade.
Madam Chair.
Senator Pappas.
Madam Chair, in all due respect, Mr. Dorr, your comments are totally inappropriate here.
Mr. Dorr, I'll ask you to vacate the table. It seems you've ended your testimony. And Reverend Tim Christopher, you may come forward. James Anderson, as you begin, please state your full name and title for the record.
My name is James Anderson. I'm from Pennock, Minnesota. I'm representing myself and many Americans who live in Minnesota. I'd just like to share some details. Recently, there was a Hennepin County drug bust. 6 people were charged. 3 of those really stuck out to me. They all had lots of drugs. A couple had money counters. Business was really good. And all had firearms. But the other point was all 3 had previous convictions for crimes that would not allow them to possess firearms, yet they all had firearms. So I'd like to believe that by bringing out these proposals such as SF 1116, you're going to help stop criminals and gun violence, crimes like this. But this will not do it. Those criminals, by their very nature, would not fill out a transfer form, would not apply for the permit. So we can't stop that crime. We have to stop behavior. And that's got to be done through enforcement. As was mentioned, we have over 40 laws on the books already. We need enforcement of those laws to put criminals behind bars for longer periods of time, and crime goes down. Washington, D.C.'s chief of police said the very same thing in the last couple of weeks. We need to put criminals in jail. Now, the other side of this proposal is that it does cause some problems. We talked about owners reporting and paperwork burdens on law-abiding citizens. There's more paperwork and work for the police in doing their work, and they're already shorthanded. They could be out stopping crime. Given that there's more work being done, I know this is free now, but when there's more work being done, the potential is there for fees in the future. Also, as was mentioned, this creates a registry of sorts for gun owners, which, as history has shown, leads to confiscation. So stopping crime is a very laudable goal, and we appreciate your efforts to try to do that. Again, it's behavior. We have to change. This proposal does not work toward that goal. We hope that you would not pass this SF 1116 from the committee and no longer put it into the process for lawmaking. Thank you for your time.
Thank you for your testimony. As you vacate the table, I'll invite forward Rob Dorr. And Reverend Christopher, as you begin, please state your full name and title for the record.
Well, thank you, Madam Chair. My name is Reverend Tim Christopher out of Beran Missionary Baptist Church. First thing, before you hit the clock on there real quick, I just got a question I need to be cleared up real quick. And that question would be on the gang involvement. Would that affect us reverends who work with gang members? I think that's something that should be cleared up right away. Would I be put on a task force? Would I be put on a list? Because I work with gang members.
Reverend Christopher, if Senator Latz would like to respond, I'll.
I think that's very important, though, for what I do, right? Okay.
Madam Chair and Reverend Christopher, there is a criminal gang investigative data system under Minnesota statute section 299C.091. I don't have that statute in front of me, but I don't think it covers people who work with members of gangs trying to help prevent violence. So
okay.
My guess is you're pretty safe there.
Thank you very much. I thank you for
Reverend
clearing that up for me. Committee, I thank you for giving me this opportunity to sit in front of you, to give you an understanding of what goes on in places that you do not visit and you do not go. What I'm saying is this here. Yesterday, a young black man, football player from Minneapolis High School, was shot in the leg while he was walking home. I say that to say this here. These bills that you're putting out here is not going to do anything for the black community. We know that. They've sat here, everyone who's testified here has said over and over and over again that these bills are not going to stop everything, right? That's what we're saying. And the places that they're not going to definitely stop anything is in the black community where we are affected big time. They're not going to do anything. So why not go after the criminals? Why not go after the people who have these guns, who are selling these guns? Let's find out where these guns are coming from. Why don't we do prevention before these kids get these here firearms? Why are we not doing that? Why are the policies that's in the black community that the Democrats are putting out there right now? Why can't we work on those policies? Why can't they pull us reverends in and sit down and talk about the things that are going on in the community to help some of these single moms who don't, and these kids that don't have fathers around, that we can do something different other than put paper down and expect paper to stop these crimes, to stop things that's going on right now. All these stores that are closing down in the black community, where are those people going to go? They're going to go to the suburbs, and all the crime and everything is going to start out there also. What I'm saying is this here. We need to start thinking about the things that we're doing. These bills, these gun bills that you guys are putting out here, not going to do anything to stop what's going on in my community, where things are going down, where kids are getting shot, right? We know that, right? Madam Chair, we know that. You and I know that. So what I'm asking is sit down with us, come into the community, and understand what
Please
we're
wrap up
doing
your testimony, Reverend Christopher.
and why these bills won't help. Thank you very much.
Mr. Dorr, please state your full name and title for the record as you begin your testimony.
Madam Chair, members of the committee, Senator Latz, I'm Rob Dorr. I am the Vice President of the Minnesota Gun Owners Caucus. And we've heard a lot about sales. This bill puts background checks on all gun sales. I wanted to give a little bit more context. The bill is actually about transfers. If I was to loan Senator Eichhorn my 300 Blackout, which is a lovely deer hunting rifle, but it has a detachable magazine, so it classifies as one of the bills that would be regulated under this. I couldn't simply loan that to Senator Eichhorn to go hunting for the weekend. He would have to go to get a permit to purchase, wait up to 30 days, and then I could engage in that transfer after I take his picture of his permit to purchase, of his driver's license, and then we both hold that receipt for 10 years. Once Senator Eichhorn's done hunting, he can't just hand me my own rifle back. Now I have to go and get a permit to purchase and get the background check done, and then we both have to hold on to that transfer for 10 years. That transfer receipt has to be held by both of us for 10 years and turned over to law enforcement upon demand, or we face a gross misdemeanor, which is up to 1 year in jail. Not with a warrant, not with a subpoena, just any law enforcement officer upon demand. That is an incredible risk to people who are lawful people who are engaging in peaceable conduct. And it is not the type of things that is going to catch the people who were actually worried about getting firearms. I think the intent of this bill is we don't want a good person knowingly selling a firearm to a bad person. And I think if that is the intent of the bill, we fall well short. The bill is much more likely to catch a good, honest, lawful, peaceable gun owner in a crime than it is to stop a single illegal transfer. According to data from the Department of Justice, less than 9% of firearms acquired by criminals come from person-to-person sales, and most of those are from family members who are actually exempted under this bill. We need to take a big look at this and actually find ways to address the things that we're looking to, not cast a broad brush and catch all of these other things. Lastly, suicides are 80% of Minnesota's gun deaths. Largely greater Minnesota, people who aren't prohibited from owning guns. We need to think bigger than just this bill. Thank you.
Thank you for your testimony. That concludes our testifiers. I will just ask everyone to please remain respectful. I know that folks are very passionate about this issue. I want to thank all of our testifiers for sticking to the time limits. I'll ask Senator Latz for any final words before we go into discussion.
Thank you, Madam Chair and members, and I really appreciate everyone who came to testify today, some of whom came from quite some distance to do so. I just want to make a couple of follow-up comments in response. There are, as already identified, some limited exceptions in the bill, but perhaps I ought to state what they are so the public understands them. This requirement does not apply to the following transfers: a transfer buyer to a federally licensed firearms dealer, transfer buyer to any law enforcement agency. To the extent the transferee is acting within the course and scope of employment and official duties, a transfer to a peace officer, member of the armed forces, or a federal law enforcement officer, or a security guard employed as by a protective agent licensed. A transfer between immediate family members, which means spouses, domestic partners, parents, children, siblings, grandparents, and grandchildren. And on that point, let me say, you start getting out to extended family members, not everyone knows everything about the backgrounds of everyone in their family, especially when you get out to extended family members. So you might not know if a particular cousin has a conviction for a domestic assault that prohibits them from possessing a firearm. In fact, they might have tried to keep that as quiet within the family as possible. So there's a reason why this limitation is described narrowly. A transfer to an executor, administrator, trustee, or personal representative of an estate. Transfer of an antique firearm. Transfer of a curio or relic. Temporary transfer of a firearm if the transfer is necessary to prevent imminent death or great bodily harm. The person's possession lasts only as long as immediately necessary to prevent that death or harm. Transfers buyer to an auctioneer who's conducting an auction. At a shooting range that operates in compliance with the performance standards under state statutes. A lawfully organized competition involving the use of a firearm, or participating or practicing for a performance by an organized group that uses firearms as part of the performance. While hunting or trapping, if the hunting or trapping is legal in all places where the transferee possesses the firearm and the transferee holds all license or permits required for hunting or trapping. At a lawfully organized educational instructional course. And while in the presence of the transferor. So that last exception, while in the presence of a transferor, if Mr. Dorr wanted to give Senator Eichhorn his pistol, if they remained together during that period of time, they could do that. It'd be different if Senator Eichhorn were going to take it away for the weekend and use a pistol or a SAM-saw for hunting. I respectfully submit, most people don't use pistols for hunting, at least not the information I've been given, and most people don't use semi-automatic military-style assault weapons for hunting, or if they do, they're a pretty bad shot. And then, of course, you can't engage in this transfer if you have reason to believe that the person who you're transferring to is not lawful to possess it. Or if you believe that they use or intend to use a firearm in the commission of a crime. So a lot of exceptions there. And a lot of people who oppose this bill, in my experience, when I have conversations with them, they all thought that they wouldn't be able to do some of these things, but they are allowed to do it. It does not surprise me that the issue of a registry has come up, because that is a very common attempt to misrepresent what this bill does. It's used that way because there were versions in previous years that could have been used to create a registry. And now, because that is a term that activates opponents, it is used even when the factual basis is no longer there. There is no central repository of any gun transfers here. The transfers can occur privately, and only the two parties to the transfer need to maintain the information about the transfer. So there isn't a way for a central repository to be put together. Now, the local law enforcement agency will have a record of those to whom permits have been issued, but that's a different question. Just to clarify, it is a 10-year retention period, and by the way, that is for the record of transfer, and that is a change, as are many of the changes that are in here over the years, based on input from people who had concerns, questions, across the political aisle. I've been working on this bill for probably a decade now, had many conversations with Republicans as well as Democrats, with stakeholders who are interested, gun owners, organizations, and so on. And the bill you have in front of you reflects changes made because of that input. There was a note about an abused partner trying to run out and purchase a firearm to protect that partner's self that day. The fact is, most abused partners at risk are women. And the data shows that in the vast majority of cases, when the women possess firearms, the firearm that they possess when it's in a domestic partner abuse situation ends up getting used by the male perpetrator to harm the woman. That's the evidence. There was a long list of firearms massacres that were given to us, and the fact is, although they make the headlines, that's not when most gun deaths in the United States occur. Every day in the United States, the equivalent of these mass shootings occurs in ones and twos on the streets and in the homes around our country. That's where, if we really want to make a dent in preventing firearm death, we need to be focusing our attention. So the facts are, members, that the public understands this. There is very broad public support, 67, 80, 90%, depending on where you are, support background checks. Because they don't want people who are unlawful to possess firearms either. And that's in rural Minnesota, that's in metro Minnesota, that's Democrats and Republicans, that's gun owners as well. A majority of all those categories, a very strong majority, support a background check bill. So members, I welcome your questions, comments, concerns. I'm happy to answer them or address them as I can, and I will ask for your support. Thank you, Madam Chair.
Senator Seeberger.
Thank you, Madam Chair. Senator Latz, thank you for all your hard work on this bill. And thank you for engaging in conversations with me about this bill. I think we all come from the same place of wanting to keep guns out of the hands of folks who shouldn't have them. And I think it is important that we try to walk that line. And this is hard work. This is hard work to understand the needs to prevent more gun violence, which are legitimate needs, and also the rights to possess a firearm if you're not otherwise not qualified to do so. This is a tough line to walk, and I appreciate all the work that you've done and all the conversations you've had and all the listening you've done on this bill. I also appreciate the folks who have reached out to me. Since last night at 6 p.m., I'm looking at my inbox right now, I have 536 new emails. So thank you for all your contact, both pro and against this bill. Thank you for reaching out. I've spent probably more time on this bill than any bill that I'm actually the author of, because my constituents feel different ways about this bill. And I've done a lot of listening, and I've done a lot of reading. I have read through this bill forward and back so many times to understand the process and what it really does, to understand what it's getting at and what the obligations are going to be on lawful gun owners who want to transfer a pistol or semi-automatic military-style assault weapon to someone else, and what the person who wants to receive it, what their obligations are as well. One concern I do have is with regard to the record-keeping requirement, and Senator Latz discussed that a little bit. As I understand it, in a private party transaction, outside of the purview of going to a fleet farm or doing it at a gun show, it's two private parties in this transaction. They are obligated to make a record of this transfer and keep that record for 10 years. It was 20 years. With this A3 amendment, it's reduced to 10 years, and I've had many conversations on that. I have important papers too. We have a lockbox and a safe at my house. I've uploaded things. We have a safe deposit box. So there's important things and I get it, there's important papers and records you have to keep. But where I got a little bit tripped up is that if law enforcement asks you to produce that record and you don't have it anymore, this law makes that a gross misdemeanor. And that feels a little onerous to me. I feel like if you are in good faith doing everything you need to do, getting your background checked, making the record, keeping the record, and for some reason something happens where law enforcement comes in and demands this record, which it is compulsory that you produce it, and you can't because you lost it, or the dog peed on it, or something happened, your house burned down, or your hard drive failed, or whatever it was, now you're guilty of a gross misdemeanor, and that just feels a little unfair to me. So I'd like to introduce the A6 amendment.
Senator Seeberger introduces the A6 amendment. While that's being passed out, would you like to explain, Senator Seeberger?
Thank you. The A6 amendment would reduce this from a gross misdemeanor to a misdemeanor. I feel like there probably should be some teeth to make sure that records are retained, especially important records such as these. But I think holding people to a standard of a gross misdemeanor when, maybe in year 9.75, your hard drive crashes or your house burns down or you can't find the key to your safe. I've had that happen to me too. I feel like this is a more equitable result. It reduces it from a gross misdemeanor to a misdemeanor.
Senator Latz?
Madam Chair, first of all, I appreciate Senator Seeberger's work here, and she certainly does her homework. Evident from my conversations with Senator Seeberger on this bill. She knew everything in and out as we talked about it, and I respect that and appreciate that. I do want to clarify something that was stated earlier by one testifier, which is a law enforcement officer can't just randomly walk up to you and ask for proof of any transfers. It has to be as part of a criminal investigation, and that's in the language that's here, just for the record to clarify that. My concern about this is that a misdemeanor may not be enough teeth on this as an encouragement for someone to keep the record. But I'm going to respect the intent here. Misdemeanor crime is punishable up to 90 days in jail. So at this time, I'm going to accept this proposed amendment as a friendly amendment and encourage the committee to support it.
Thank you, Senator Latz. Senator Seeberger moves the A6 amendment. All those in favor say aye. Aye. Opposed? Okay, the amendment is adopted. And to the bill as amended. Senator Limmer.
Thank you, Madam Chair. Since we're on this subject, Senator Latz, let's suppose there was a private transfer, 8-9 years go by. What would cause a law enforcement officer to want to look at a transfer from 8-9 years in the past? People move. People may not even remember where exactly they purchased that gun. But I'm more curious about what would cause a police officer to want to check and search for the seller of that gun after 8 or 9 years goes by, and why would we hold that individual culpable in any violation after that long of a period of time? The time factor is more my concern.
Senator Latz.
Madam Chair, Senator Limmer, once guns are out in the community, they can be transferred and they can be used. And sometimes firearms are recovered at a crime scene. If there's a way to identify the perpetrator through a fingerprint or something else, they can obviously do a search of that shooter's personal belongings, house, and so on. And if they find records of transfer, then they can know who the firearm was purchased from. There may be several steps along the way there. It may be only one transfer that occurred 10 years ago. But it might be a valuable part of the investigation for the law enforcement to determine how the shooter got the firearm. So that would be the kind of scenario I would envision. Gun may sit in a drawer for 9.5 years and someone decides they're going to go use it in an unlawful way. I preferred 20 years. Law enforcement indicated to me that, the longer that the records are available, the longer they'd be able trace the provenance of a firearm used in a crime. The 10 years was a compromise position, and hopefully that will cover what's necessary to help track down how a firearm got into the stream of commerce and how it ended up in the hands of the shooter. It's also, I think, valuable because it impresses upon the seller as well as the buyer the importance of having records, of having checked on the transferee permit, and the significance of having the records available when there is a criminal investigation. So if you say keep it for 30 days and then you can shred it, well, that doesn't tell you the paperwork is very significant. If you say keep it for 10 years because we want to be able to have the criminal investigations successful, well, that tells you it's a pretty significant document, and maybe you ought to think about keeping it like you're supposed to.
Mr. Chair.
Senator
Madam
Limmer.
Chair, Senator Latz, the federal government doesn't even require us to hold our tax records for more than 7 years. So, and in some cases, one could have more damage done to them because they did not keep their tax records for a full 7 years. If an audit was required, then what some would consider an investigation by law enforcement up to 10 years down the road. So I find the 10-year holding period quite lengthy. I find it, and if you know anything about my record keeping, I don't keep anything. Well, I probably do keep everything. My wife would say I keep everything for much longer, but we're trying to change that. I'm trying to streamline my life. A 10-year document to hold, I don't think I hold anything for 10 years. So I find that to be above and beyond a practical holding period.
Madam Chair.
I have a list. I'll put you on, Senator Howe, but first we'll go to Senator Westland.
It was on this point.
Sorry. Thank you, Madam Chair. Thank you, Senator Latz. I said it privately. I'll say it here. I am deeply grateful for the work that you've done on this issue. You've been a champion for trying to make our communities safer for a very long time. And I'm pleased that we're finally having a hearing on this issue and folks have an opportunity to come and express their opinions both for and against the measures. So thank you. Thank you, Senator Seeberger, also for the good work that you have done to try to make this the best bill possible. You've been thoughtful throughout this process, and I appreciate your efforts on this as well. I do want to ask a couple of questions that came up in the context of the testimony. We heard a lot from opponents about a registry, Senator Latz, and I'm not sure if you specifically addressed that, but we have opponents claiming that this is going to create some sort of a registry, which I am having a little trouble wrapping my head around because, as you noted, 60% of purchases are already covered by background checks, and this is simply trying to make sure that we're doing them on all of them. So what's your response to the statement that this is going to create some sort of a registry?
Senator Latz.
Madam Chair, Senator Westland, when I think of a registry, I think of a centralized place where records would be kept, and to deal with the issue that is presented, the government, if they wanted to, could go find out who's got any guns and go confiscate them, right? That's the argument that's always made. The government's coming after us. They're going to take all of our guns away. As you already noted, Senator Westland, the federal government already has records of all the background checks that are done through FFLs. So there's a 60% or greater number of firearms subject to this registry, if it could be said to exist already, and a lot of willing participation in that process. So I don't But the other thing is, here, there's going to be a federal background check run through the local law enforcement agency for a particular individual, just like if you went through an FFL, except it's done here as a part of an application for a permit, a transferee permit. So we may know, who's gotten permission to purchase a firearm. We don't know where any particular firearm is. We wouldn't under any of the circumstances here. And the background information, who's actually issued the permits, they're all kept by the local law enforcement agencies, so there's not a really central repository. Now, I'm not as concerned about the government going out and trying to confiscate everyone's guns. I think that would violate the Second Amendment, and would be a pretty bad idea anyway. But, I respect those who have those views. I don't see it as a result of the bill that you have before us today.
Madam Chair.
Senator Westland.
Madam Chair, Senator Latz, I appreciate that. You've also mentioned a couple of times in your comments today that the bill that's before us today is very different from some versions in prior years and probably some versions that have been circulating this year. And it seems to me, and you can confirm this perhaps, that you have elicited input from all stakeholders, both those who are supportive of gun safety measures and those who are not. Is that accurate, that you have been attempting to incorporate input and views from all sides of this issue?
Senator Latz.
Madam Chair, Senator Westland, yes, the answer is yes, but I would take just a little, I would take a different nuance in the way you characterize it. I think all gun owners and all others are in favor of gun safety. I think we may take different approaches to how to achieve that, and I think it needs to be a multi-pronged approach. There are those who joined us at the testifier table today and on the committee who think the strongest thing that we can do is ramp up criminal penalties for gun crimes. And I've supported increasing criminal penalties for gun crimes, not necessarily as much as perhaps some members of the committee have introduced, but I introduced and got passed into law the straw purchase bill at the initiation of my own county attorney 7-8 years ago. So I think this is an important piece of it. And the fact is, if you don't have a mechanism to identify people who are trying to obtain firearms that would be illegally in possession of the firearm or would be a serious danger to themselves or other people if they got the firearm, if you don't have a way to do that, then you've got complete lawlessness. Then you've got no control over the situation whatsoever. If I were a gun owner, I wouldn't want to sell my firearm to my neighbor who I know has engaged in a violent criminal offense, nor would I want to sell it to someone down the block that I don't know what their background is either. And they're certainly not going to tell me, and it may not be part of the neighborhood lore. Even if I've known them for 30 years, they may have something that happened to them that they didn't share with me, but that would be picked up on a background check because it's part of the legal framework. So that's the way I approach it. This is a preventive measure.
Senator Westland.
Thank you, Madam Chair. Thank you, Senator Latz, for correcting the nuance there. I would like to hope that every person who is a gun owner and a non-gun owner has as our intention to make our community safer, and that includes gun safety issues. And again, I have remarks that I will save to the end, but I think those are my questions for now. Thank you again, Senator Latz.
Thank you. We'll go to Senator Howe and then Senator Kroon. Senator Howe.
Thank you, Madam Chair. And going back to the keeping the paperwork for 10 years is, and you said it's a compromise from 20 years. I guess I don't understand why we're keeping that paperwork for that length of time. I'm trying to figure out why and how you keep that paperwork. And I can remember I came home from a deployment. My wife had done some housekeeping, and I couldn't even get into my safe because she threw away the combination of the safe. So I think you're putting some folks in a real dangerous situation to try and keep it and maintain a record of something for 10 years. I don't know how you do that. I mean, I'm more of a gun collector than a seller. I mean, I can tell that I've sold 4 guns in my life, and I can tell you exactly who I sold them to. I got no record of any of them. But I know who I sold them to. I know what gun they are, and I can find the serial number because I keep the serial numbers of my guns. But I don't have a record of that transfer, except for in my head. But I take it that's got to be a written transfer because we're going to require it to be a written transfer. And I'm going to have to do that through an FFL, I take it, which is going to cost somebody some money. Is that not correct?
Senator Latz.
Madam Chair, Senator Howe, you would not have to do a transfer through an FFL under this proposal. It can just be a direct transfer, one-on-one.
So I don't.
Senator
All you have to do
Howe.
is take a picture on your phone of the transferee permit. And that's all, as long as you keep that, you'd be fine.
Senator Howe.
So I need that transferee permit or a permit to purchase in common language is what most folks use is permit to purchase, which is going to cost, if you got a permit to purchase, it's going to cost you dollars to get that permit to purchase.
Senator Latz.
Madam Chair, Senator Howe, no, that's not the case. Under this bill, there would be no charge for that application.
So
Senator Howe.
Thank you, Madam Chair. So Senator Latz, the only place you need it is when you got a permit to carry is where you got to charge.
Senator Latz.
Madam Chair, Senator Howe, that's correct.
Senator Howe.
Thank you, Madam Chair. So I want to go back to the comment about using a handgun or a military assault weapon for hunting. Senator Latz, have you ever gone fox or coyote or any hunting at all? What type of hunting have you done in the past?
Senator Latz.
Madam Chair, Senator Howe, when I was a child, I had a friend whose family hunted down in Windham, and I went with them duck hunting.
Senator Howe.
Thank you, Madam Chair. So you've never gone coyote hunting or fox hunting where you've got an animal that's not very large, that's running at a high speed, and you're trying to connect a little .223 round or a .556, which is coming out of what you would call an assault-style weapon in this definition. The reason you have a 20 or a 30-round magazine, because it's going to take a couple rounds to connect with them. Now, I have watched my dad, who I think was the best shooter I ever met, connect with a fox at 80 yards as it was running across a plowed field and shot it in the back of the head with a .223. I couldn't make that shot, and I am a trained sniper, but he could make that shot. So what I'm saying, when I go hunting, I do take a military style assault weapon when I'm hunting fox, coyote. In fact, some of my kids have used it to hunt deer because it's a legal weapon to hunt deer, legal caliber. And the reason they use it, because they've all been trained in the military. It's a weapon they know. They can, if it has a failure, they can take it apart, put it back together, and get it working again. It's a known weapon. They know how far it shoots. They know where it shoots. To say that that's not a weapon, not a firearm that they should be allowed to use, I think is ridiculous. And I think it's ridiculous to sit there and say that does that have different rules for the transferee?
Senator Latz.
Madam Chair, Senator Howe, this bill does not restrict anything relating to what kind of firearms you can use to go hunting. Not at all. What it does say is that what are more typical hunting weapons, as I understand them to be, are not covered by this background check bill. SAMSA would be covered by this background check bill. Now, I might ask, where's the sport in trying to shoot a fox at 100 yards with a 30-06 instead of a machine gun? But this bill doesn't say anything about that. What it does say, if you're going to go buy a SAMSA from someone else, you have to have a permit to purchase first.
Thank you, Senator Latz. And
Well,
again,
Madam Chair.
the exclusions start on 13.31. The hunting exception is on line 15.6. Senator Howe.
Madam Chair, so Senator Latz, your analogy of using a machine gun, that takes a special permit to own a machine gun. Very few people go through the requirements to get a machine gun because it's so onerous and it puts a spotlight on you. Very few people own a machine gun. In fact, I only know one person that I know of that has the permit to fire a machine gun and own and possess a machine gun. Not very many people. If they own a machine gun, usually in the state of Minnesota, they're known by the ATF. They're on a map. And if they have them shooting in Minneapolis, they should be behind bars. And I don't think this is going to get to putting those folks behind bars. So your analogy saying that it's not much of a sport to use a machine gun or a 30-06 to shoot a fox at 100 yards, I will tell you that you can actually load a 30-06 down to take a 100-grain bullet, in fact, less than that, and it makes an excellent weapon or firearm to go shoot and hunt fox or coyote. So what I'm saying is, it just upsets me that you've gone down this road and you typically talk about us folks that like to use these firearms to go hunting, and you really don't have the background as far as what we're doing and how we use these firearms to do. But let's go along. After that, you said that I'm going after the piece where how do we determine the law enforcement officer has the determination of whether the person may be a threat to themselves or others? Where is the criteria that identifies how they come to that conclusion? Or could they possibly determine that everybody that has a firearm is a threat to themselves or others?
Senator Latz.
Madam Chair, Senator Howe, I just want to emphasize with the previous conversation that this bill does not restrict, I will say it again, this bill does not restrict what kind of firearm a person can choose to use while hunting. Not at all. All it says is that if you're going to purchase a pistol or a semi-automatic military-style assault weapon, you need to go through a background check first. That's all this bill does. Now, with regard to the question that you asked, I'm going to refer you to let me just find the proper section here with regard to the grounds for disqualification starts on page 6 of the amendment, subdivision 5. The language is whether or not a person is determined to be a danger to self or the public when in possession of firearms. And the standard is on line 7 starting on line 7.4, whether there exists a substantial likelihood that the proposed transferee is a danger to self or the public when in possession of a firearm. The guidelines for that are not specified in statute. And honestly, I don't know that it'd be very productive to list a non-exclusive itemization of those criteria in statute. We could put a list of things that might be considered or allowed to be considered, but I don't think that's necessary. There is very detailed right to review. The chief of police or the sheriff must provide the applicant with a written notification and the specific factual basis justifying the denial, including the source of the factual basis, and inform the applicant of the applicant's right to submit within 20 business days any additional documentation relating to the propriety of the denial. And then the chief of police or sheriff must reconsider the denial and within 15 business days tell them the result of that reconsideration. Then the applicant has a right, if they still disagree with the outcome, to get review of that denial under subdivision 13. So there aren't any itemized criteria, but there is ample opportunity for review, and the applicant is entitled to know specifically and in writing what the grounds are for that denial. In subdivision 13, it provides for appeal to the district court and prompt review, a hearing within 60 days, and a sealing of the record to protect the applicant's privacy, written findings of fact and conclusions of law relating to those issues, and the burden of proof being on the law enforcement agency to establish by clear and convincing evidence that there exists a substantial likelihood the applicant's a danger to self or the public.
Senator Howe.
Madam Chair, so Senator Latz, we've increased the waiting time for the allowable time for them to issue the permit to purchase from 7 days to 30 days. Is that not correct?
Senator Latz.
Madam Chair, Senator Howe, 5 days to 30 days, I believe.
So 5 days.
Senator Howe.
Thank you, Madam Chair. So is the 20 days after the denial, or is that during the 30 days? So,
Madam Chair, Senator
Senator
Howe,
Latz.
the right to appeal or seek reconsideration starts after the denial occurs. That's what triggers that running of the 20 days.
Senator Howe.
so they get the, Senator Latz, so I'm saying that they get the sheriff or the chief gets 30 days to process the transferee request, the permit to purchase. And then once they get the denial out, they get another 20 days after that to give them the list of why they denied it? Or is the 20 days inside of that 30 days? I'm just trying to figure out, do they have 50 days to tell them why? Or do they have 20 days to tell them why? Does the 20 days start when they receive the application, or does the 20 days start after the denial, so they actually have 50 days before they have to release why they denied the permit?
Senator Latz.
Madam Chair, Senator Howe, if you read subdivision 5, please, it indicates that the chief of police or sheriff must inform the applicant of the applicant's right to submit within 20 business days any additional documentation relating to the propriety of the denial. So the sheriff has 30 days to run the background check, gather whatever information they wish to gather. It may take them 5 days, it may take them 15. They have up to 30 days. Once they issue a denial, then the applicant who's been denied has 20 business days to submit additional documentation.
Got it.
Once that additional documentation is submitted, then the sheriff or chief has an additional up to 15 days to reconsider it and issue a decision on reconsideration.
Senator Howe.
Thank you, Madam Chair. So Senator Latz, we're looking at up to 65 days to get a permit to purchase. That's what we're looking at. You've got 30 days to respond. He's got 20 days to respond to the denial and provide additional information, and you got an additional 15 days for them to respond. To me, I'm not a great math guy, but I'm adding it up, and that's 65 days that this process could take to get a permit to purchase or a transferee permit.
Madam Chair.
Senator Latz.
Senator Howe, 20 of those days would be in the entire discretion of the applicant who's been denied, how long it takes them to get additional information asking for that reconsideration. But yes, theoretically, it could take up to 65 days, but they would have notice of their denial within the first 30 days.
Yeah, agreed.
Senator Howe.
Thank you, Madam Chair. Senator Latz. I'm just trying to get all these timelines down. So let's move on to, you got a person that may end up on a gang list that's provided by whoever, and some, you know, if you've got the name of Johnson, you might have a lot of folks that you might have the same name as, or so if you end up with the same name as someone and you're trying to document, and you end up on that, and I haven't looked in the bill because I just got it, and I've got a hand that doesn't work, and I'm struggling going through the bill, but. So if I end up on that list, and I just remember when you were going through the bill, introducing it, you said down the road you can reapply. What does that down the road, how long afterwards can they reapply if they get denied? And if they get denied, how long after if someone is not on the gang task force and they apply, they get denied, they can reapply, how long down the road, how much time can pass before they can reapply for a permit to purchase if they've gotten, you know, these items, that the reason that they got denied the first time and they get those items fixed, how long down the road can they reapply for a permit? Can they immediately reapply, or do they have to wait a certain amount of time for reapplication?
Senator Latz.
Madam Chair, Senator Howe, they could immediately reapply if they chose to do so, but the chief or sheriff would not need to process an application unless at least 6 months have elapsed since the denial was issued or the appeal was denied, whichever occurred later. So, as a practical matter, unless there were new information that were presented to the chief or the sheriff that would justify, you know, a reopening of the application process, it would be a 6-month time frame before the chief or sheriff would have to consider a new application.
Senator Howe.
Thank you, Madam Chair. So what's the purpose of the 6 months?
Senator Latz.
Madam Chair, Senator Howe, so that a person who's denied can't come in every week and submit a new application and start this process over and over and over and over again based on the same information.
Senator Howe.
Mr. Chair, Madam Chair and Senator Latz, I don't know who would do that, but I'm thinking it would be a pretty simple process to deny, I would think. They've already got the documentation and all this stuff. They'd have to just hit reprint, wouldn't they? I mean, I don't know.
Madam Chair,
I think
Senator Howe,
and why is 6 months the deal? How did we end up with 6 months? Is that just pulled out of the air? Is there's something that actually documents why you do 6 months instead of 30 days or 45 days?
Senator Latz.
Madam Chair, Senator Howe, every time there's an application, the chief or sheriff has to go through a specific process for the background check, and they have to provide in writing the grounds for denial. So it's not just a matter of pushing print on a computer. There is cost involved, public taxpayer cost involved every time the sheriff's office goes through the background check. They're checking the federal databases, they're checking Minnesota court systems and other databases that they believe are relevant. And depending on the circumstances and what information they gather, they might have to do some interviews or gather other information as part of the process as well if they begin to suspect that the person may be a danger to themselves or to others. So, no, they can't just push reprint. Now, how do we come up with 6 months? There were those who wanted to have these permits issued for every proposed purchase of a firearm. That was not the case here. There were those who wanted to have these permits valid for only 30 days, so you'd have a window of 30 days, and that you could only buy up to 5 guns with the permit. That was rejected. There were those who wanted to prohibit going back through the process for a whole period of a year. That was rejected. It seemed to me and to the other stakeholders involved in coming up with these conclusions, after consultation, as I've noted, with a variety of views on this point, that 6 months was a reasonable period of time, that if there were any change in circumstances, there was a reasonable possibility that might happen within 6 months. And it wouldn't require anyone waiting too long to try again.
Madam
Senator
Chair.
Howe, if you have another question, and then we're going to move to Senator Kroon.
Well, in that case, I guess I guess my time is up, but I will ask then, I don't believe this does anything to increase the mandatory minimums for felons in possession of a firearm. And I think that's what we should be looking at, because those are most of the folks that are actually getting to this. You know, the way it looks at, on the average, it looks like a number of folks get reduced sentences. The mandatory minimum is 60 months in Minnesota. The maximum is 15 years. How come we're not looking at that and actually making the mandatory minimum that you're going away for a long time if you're a felon in possession of a firearm? Can you answer me why we're going after folks? The majority of folks have the firearms that we own. It's always up to the perpetrator that does this, and they usually are reoffending folks, but we're doing nothing, and most of these folks get plea bargained down. They don't even get the felon in possession of a firearm. We plea bargain that down, and they get off earlier than what even the mandatory minimum is. So we should be, in this bill, Senator Latz, looking at increasing the mandatory minimums for these. In fact, if you're convicted of a crime in the possession of a firearm, it should be increased mandatory minimums. But that's not what we're looking for here. This, to me, is looking to make those of us that have been obeying the law all along criminals. And that's where I start to have the issue. Thank you, Senator Latz.
Senator Kroon.
Thank you, Madam Chair. I'm going to go all the way back to the very beginning of your presentation. I believe you said, Senator Latz, that 60% of purchases go through the federal background check, which then, by implication, up to 40% do not. And I've heard that statistic out in the political atmosphere out there for a while now, and I'm just wondering what the source is for that statement.
Senator Latz.
Madam Chair, Senator Kroon, I can't cite you the specific source for that. I've been using it for quite a number of years. I don't remember precisely what the database was that I got it from, but that's my understanding.
Madam Chair.
Senator Kroon.
Thank you, Madam Chair.
I should hasten to add, I'm sorry, Madam Chair.
Senator
Kroon,
Latz.
because we don't know exactly how many transfers there are, there's no way to be precise about that. So we're ballparking it.
Senator Kroon.
Thank you, Madam Chair. And I think you used the word purchases, and that's why I'm asking about it in your opening statement, because I'm looking at something from factcheck.org, which isn't exactly a conservative publication, that said that figure is based on a 2-decade-old survey of less than 300 people. And the question about guns in that survey was how they acquired the firearm, not necessarily about purchasing. So, and that leads me to my next question, which is when I hear about this issue out in the community and stuff, most people think of this as kind of like closing a loophole on backgrounds, and everybody thinks about it as purchasing, but really this to me is about transfers and what we're trying to get at here. And so I just want to confirm with you, because I didn't see anything in the bill or the A3 amendment, there are no minimum thresholds on the number of firearms you have to transfer in a year or over a period of time in order for this bill to apply. Is that correct?
Senator Latz.
Madam Chair, Senator Kroon, that's correct.
Senator Kroon.
Thank you, Madam Chair. So if you have one transfer, if you do one transfer a year or even one transfer in your life, this bill is going to apply to you. And I think a lot of people out there that think about this, they're thinking of the person who's trying to do an end around about what sellers of firearms, the requirements for those sellers. And they don't think about the person that, does 1 or 2 transfers in their lifetime, or Senator Howe, who's done 4 in his lifetime. And so to me, that there should at a minimum be a minimum threshold in here for this bill to apply. So we're not ensnaring people that aren't in the regular business of buying and selling firearms into this kind of rather complicated process. That's a comment. Then my next question is, you mentioned that there is recourse in court for a denial of a permit to purchase, but is there any recourse to go to court for a revocation of a permit to purchase?
Senator Latz?
Madam Chair, Senator Kroon, with regard to your first comment about minimum numbers, I don't know how we could ever, as a practical matter, do anything about that. We'd have to rely on someone's representation that they've never bought a gun before. This is their first time. So there's no way as a practical matter to do that kind of a threshold. But in terms of your second question with the revocation, I don't know off the top of my head what the provision is in here, if there is, what the appeal process is for that. So if you give me a moment, I'll see if we have it here, or perhaps counsel knows off the top of his head where that provision is.
Mr. Backus?
Madam Chair and members, I'll have to read the bill a little more closely, but the language I'm looking at appears to limit the reconsideration to a denial of the application. I don't think it applies to a revocation. I could double check though and read it closely.
Senator Kroon, do you have any final questions?
Madam Chair, I have more questions. I was waiting for Senator Latz, but I can certainly move on, and then he can jump in
Yes.
on either
Go ahead,
questions.
Senator Kroon.
And that does lead me to a similar issue here, where I know in the A3 amendment, compared to the original bill that I was looking at before, it does appear that some new language is adopted regarding that hearing upon the denial of a permit to purchase. And I think that language may be borrowed from the permit to carry, or maybe something the other body did in one of their hearings. I'm not sure. But one thing it doesn't do is provide for attorney's fee provision. And my concern here is that you have, you could have a city or a sheriff who, let's say, is not very friendly to the Second Amendment, and maybe makes a habit out of denying these, or denies them in situations where perhaps he shouldn't. And then the law-abiding gun owner then has to go to court and take a city or a sheriff to court and go through the whole process for a constitutional right. And then at the end of it, if they're proven right, they're out, $2,000-3,000, in attorney's fees if they want to do it right and get an attorney. And there's really nothing that they get for that. And so that's a concern of mine, but there's not really a question there. And I'm also concerned that it doesn't appear to me that there's any due process for a wrongful revocation of a permit to purchase. And then another question I had is you have in your exceptions here, after death, a personal representative or whatnot, being able to acquire a firearm by operation of law after the death of somebody who owns firearms. But does that exception apply to the personal representative distributing firearms pursuant to probate or will or other means.
Senator Latz.
Madam Chair, Senator Cruin, I'd have to parse the language on that very carefully. If we need to tweak that a little bit to make sure that the smooth transfer of an executor or probate in that kind of situation, we can certainly look at language to accomplish that.
Thank you, Mr. Chair.
Senator Cruin.
And then when we get into the holding the receipt or proof of transfer for 10 years and it being, there was some discussion about having to produce evidence of that documentation when a peace officer requests the record as part of a criminal investigation, which is lines 13.22 and 13.23. And I believe it was Senator Limmer asked you a question about, you know, what would be a situation where that would happen, and you described a scenario where there's a criminal investigation going on about perhaps a firearm that was used in the commission of a crime, and that would be the reason why the police officer might request that transfer record. But my question is, in that scenario that you provided, why wouldn't the law enforcement official just go get a warrant?
Senator Latz.
Madam Chair, Senator Cruin, I suppose a law enforcement officer could go get a warrant if they had probable cause to believe that the individual who had possession of it had been committing a crime. Not sure what the standards would be if they're investigating a crime and they seek to search someone that is not suspected of a crime, but they're trying to trace the provenance of a particular firearm that was used in a crime. So it's a fair question. I think I'd like to get a little more information on how that would work.
Senator Cruin.
Madam Chair, and Senator Latz, you didn't make this statement. I believe it was County Attorney Choi, but it piqued my curiosity. There was mention of online gun sales as being part of this bill being a solution to that issue. And I'm just wondering if you or if County Attorney Choi wants to come back up, or if he's still here, if you could identify any websites out there where you can legally buy a gun without a background check and have that gun show up at your door.
Senator Latz.
Madam Chair, I don't know that that is necessarily the case, but there are a lot of transactions where the buyer and the seller are connected through online sites, and then they could decide to meet at some mutually agreed location and conduct the transfer outside of the FFL system. So I think that's part of what we're dealing with here.
Madam Chair, thank you, and thank you, Senator Latz. I just want to clear up any confusion out there, because when the public hears statements like that, they think that there are some websites out there where I can just go on, like an Amazon-type website, order a gun, not have to provide any evidence of a background check, and the gun shows up at my door. And to my knowledge, that's not legal already under existing law. And so I think we need to be very careful with our words and our testimony, especially from public officials who maybe try to make that implication out there. So that's my comment on that. And then finally, one more thing, Madam Chair, I appreciate this, the time on this. Senator Howe was asking, there was some exchanges about types of weapons that would not fall under this, common types of hunting weapons. And hunting is not my area of expertise either, Senator Latz, but I do understand that, and I've learned a lot about this, that the traditional deer hunting rifle is not the only type of weapon that is used for hunting in the state. And also that there's very large swaths of Minnesota where the only weapon you can use for hunting is a handgun, a pistol or a shotgun. And so I just wanted to clear that up, and I thank you for your time.
Thank you. Senator Latz, final comments. Senator Limmer.
Madam Chair, thank you. I want to give proper respect to Senator Latz to make the final statement, but I did want to make a statement on my own. This discussion raises lots of questions, and the discussion brings up, and rightfully so, the amount of gunfire that we're beginning to experience in the metropolitan area, especially in the urban core. Many of us, I would say all of us, are concerned about that development. And it's a real problem. But using this bill to focus on basically law-abiding citizen transactions, I consider to be an overreach. I believe many of the people that are here today that are concerned about the legislation sees it as a step, an incremental step to eventually denying rights that are outlined in our Constitution. And they're concerned about that. They have a knowledge of history in other countries that have gone in that direction. And I think everyone should be rightfully concerned. This won't cause a gun confiscation in and of itself, but it's a step in a direction that it could. I believe it's focused more so in the attempt to fix a problem. It focuses a lot of regulation on a broad, law-abiding population. Wanted to clear up a few facts. When one buys any type of weapon, you have to buy it legally through a licensed firearm dealer. That's required by federal law and state law. And a background check is required. Private transactions, I believe, are a very, very small part of gun transactions in the state of Minnesota. And for the most part, they're done by law-abiding citizens. There was a fact that was made: 60% of gun purchases are registered and 40% are not registered via a private sale. That's not close to the statistics that I've ever read. So perhaps after this is concluded, someone can give me the source of that, that figure. Some people don't know this, but I've been told that 50% of all long guns that are sold in the country now are buying the military-style long gun. They're very popular, and they represent the modern sporting rifle in the United States. They have an appearance of a military look, but they have the shooting quality of a semi-automatic rifle, and that technology has been around for over 100 years and available for civilian purchase. So it is important to consider that. We do recognize the proliferation of gun violence. And I agree with those who believe we have enough laws on the books regarding gun use. I have heard from experts in the field that Minnesota right now is considered one of the top 10% of gun regulators in the country. We have a lot of laws on the books. Recent statistics from the Minnesota Sentencing Guidelines Commission, they, for the audience, they collect facts on all sorts of criminal activities, convictions. They guide the legislature at times on sentences in regards to proportion of what the sentence should be for the crime. It has been told to us by the Minnesota Sentencing Guidelines that 40% of gun convictions, those who have been convicted, the judges do not follow the sentences that the mandatory sentences that the legislature has written into law. That should be a concern for pro-gun people and anti-gun people. The legislature tries to make an underline in our state statutes when we use the word mandatory sentence. If a person uses a gun in the commission of a crime, we in the legislature, representing you, the public, have told our judges to put the guy in prison. And there are judges 40% of the time that do not do that. That would go a long way on addressing the proliferation of gun violence in this state. As I said before, I believe this bill is overbroad, and the focus really should be on the prosecution of criminals. And what many of us know, we should also pursue a vigorous expansion of mental health services in the state of Minnesota, which has been long neglected for over 40 years. I'll just conclude that, Madam Chair.
Thank you. Senator Latz, final words.
Madam Chair, I ask for the committee's support.
Wonderful. With that, Senator Latz moves that Senate File 1116 as amended be recommended to pass and re-referred to the Committee on Finance. Roll call was requested. Roll call granted. Clerk will take the roll.
Chair Umover-Bayton?
Yes.
Senator Latz?
Yes.
Senator Limmer?
No.
Senator Carlson?
Yes.
Senator Eichhorn?
No.
Senator Howe?
Nay.
Senator Kroon?
No.
Senator Pappas? Senator Seeberger?
Yes.
Senator Westland?
Yes.
Senator Pappas?
There she is.
Senator Pappas?
Yes.
There being 6 ayes, 4 nays, the motion passes. It's sent to Finance. On to the next bill, Senate File 2827. Senator Latz, when you're ready.
Thank you. Madam Chair.
Senator Latz.
Madam Chair, Senate File 2827 increases the felony penalty for a person who owns, possesses, or operates a machine gun or any trigger activator or machine gun conversion kit from a 5-year to a 20-year felony, and the fine from $10,000 to $35,000. Members, we've all heard, some of us have seen videos of the destruction that these so-called sears can cause when they are attached to even pistols. Essentially, it's a conversion kit that can turn a single-shot pistol into the equivalent of a machine gun. rapid fire, and the destruction can be horrifying. They're on the black market. They are available to be purchased through the internet, probably on the dark web, but nevertheless. Clearly, the felony penalties that are on the books have been effective in deterring the expanded use and proliferation of these devices in our communities. So this bill would substantially increase the felony penalty for ownership, possession, or use of any of these devices. I ask for your support.
Thank you, Senator Latz. We have 3 folks signed up to testify. I'll invite the first 2 forward, Brian Ghosh and Carl Kaufman. When you're ready, please start your testimony by stating your full name and title.
Thank you, Madam Chair. Members of the Senate Judiciary Committee, my name is Brian Gosh, State Director for the National Rifle Association. Just want to point out that the increased penalty from 5 years to 20 years exceeds the current penalty for second-degree manslaughter, which is 10 years, and it puts it more on par. This 20-year penalty would be more on par with charges of sexual assault or rape. Currently, under federal law, possession of a machine gun without fitting one of the exceptions is already illegal under 18 U.S.C. Section 922. And under 18 U.S.C. Section 924A2, it puts that penalty as imprisonment of up to 10 years. So there are already laws in the books that are pretty stiff, if you will, for violating that statute. It is legal to own some machine guns, those ones manufactured prior to 1968, and certain FFLs can own and operate machine guns. You could have a situation where somebody served in World War II and maybe their grandchild gets a hold of a operable machine gun. You would be looking at imprisoning this individual for up to 20 years, even though they have not threatened anybody, not inflicted any harm, and not used it in a way that would cause harm. Just mere possession of this instrument, you would imprison somebody for up to 20 years. If somebody does use a machine gun currently in a crime, there are already laws in the books to imprison that individual for a long time. So if it's attempted murder, aggravated assault, and so forth, there are already laws in the books to penalize them for a much longer period of time than the current 5 years. Thank you, Madam Chair.
Thank you, Mr. Gosh. You may leave the table, and Ben Dorr, you may come forward. Mr. Kaufman, when you're ready, state your full name and title.
Madam Chair and members, my name is Carl Kaufman, and I'm here as a member of the NRA. I'm a lifetime member of the NRA, a concealed carry permit holder for more than 20 years. I'm here today to state my opposition to SF 2827 pertaining to machine guns. This law is covered by the federal law. So again, I think this is somewhat redundant to do this. Now, I understand, according to Senator Latz's comment about auto sears, I do understand that. If that is the case, then those federal laws need to be applied to any of the violations used with that type of a weapon. They are illegal, and they have been, and they will remain so, according to the Act of 1934. The penalties for your outstanding citizens of Minnesota that pay taxes, they vote, the violations for them are exorbitant compared to that of a drug charge. So I think in that respect, it's unfair. On the other hand, I will say that it's questionable to lump them all together. What is the definition of a trigger activator? I did have a question on that. it makes criminals out of collectors. And if you're a collector, you know, it's gonna challenge you on how you purchase and how you look at maintaining your inventory. Ultimately, we need to enforce, we need to
Please wrap up your testimony.
prosecute, and we need to sentence accordingly. Thank you very much for the opportunity today. I appreciate it. One comment?
Sure, Mr. Kaufman.
In 30 years, Mr. Latz, I have missed one big game animal, and that's all I've missed. Thank you.
Congratulations.
Thank you.
Thank you, Mr. Kaufman. Mr. Dorr, please state your full name and title for the record when you begin.
My name is Ben Dorr. I'm the Executive Director for Minnesota Gun Rights. Madam Chairwoman, members of the committee, Senate File 2827 is a laughable joke to anybody who isn't a Kool-Aid drinking leftist. This bill is the definition of a feel-good measure that will have exactly zero impact on lessening crime in your inner-city gang fights. It's because we don't live in 1990s Die Hard 2 where everybody's running around with fully automatic machine guns on snowmobiles. Virtually nobody owns them, and they're a non-factor in your DFL-controlled inner-city crime sprees. When your voters burned down Lake Street in the summer of violence in 2020,
I'm going to object.
to our knowledge, there was not a single
Mr. Dorr,
gun to be used.
Madam Chair,
Senator
I would like to say that we have had an extremely respectful conversation today by people who have reasoned disagreements about things. And you have been extended respect as well, Mr. Dorr, in spite of the fact that you have failed to show the same for the people sitting in this room.
I'm showing respect to the
You
Constitution.
provided a written statement, Mr. Dorr. You provided a written statement to this committee. It is a waste of our time to have you read that statement to us. It is insulting. It is disrespectful to people who are here trying to make decisions and take in information that's actually helpful to that process. This is not helpful to our process. It is inflammatory, among other things, and frankly, it doesn't reflect well on you or your organization. And I'm going to ask, Madam Chair, that Mr. Dorr, since he has submitted this statement to us in writing, that he not be permitted to simply read it in this committee.
Mr. Dorr, you have a minute and 20 seconds left. I would encourage you to provide some additional information to the committee. I'll give you your final minute and 20 seconds. We do have the letter in front of us, so we're all able to read that.
Great. Sure. Well, this, like I said before, thank you, Madam Chairwoman, and thank you, Senator Westland. I'm here on behalf of our membership to tell this committee and to tell those who want to take our Second Amendment freedoms away that the members of Minnesota Gun Rights are not going to sit by and watch that happen. We spend money at election time. We have vast quantities of members and supporters, patriots across the state who don't want their Second Amendment rights tread upon.
Madam Chair.
Since we're only given a minute and 20 seconds to speak total.
We can stop the clock. Madam Chair,
Senator
Mr.
Pappas.
Dorr, it's really, really grossly inappropriate to talk about and make threats, election threats. Please direct your comments to the bill in front of us.
Mr. Dorr, 30 more seconds.
Is that the chair's request that I direct my comments that way, or?
I will give you 30 more seconds, as I stated.
Great.
We have the letter in front of us. I'm giving you your full time, and
Thank
I'd
you so
ask
much.
that you provide us some additional information other than what you've included in the letter.
Which is what I was doing. Again, we don't like this legislation. Our members don't like this legislation. It's a feel-good measure designed to make people feel good while not lessening crime and not solving the problems that you claim to be here to solve. So we ask that this committee vote no on this bill today, and we will let everyone know what the results are of this vote and every subsequent vote. Thank you so much for the time.
Thank you, Mr. Dorr. Senator Latz, any comments before we go into discussion? Okay. Senator Howe.
Mr. Chair, thank you, Madam Chair. And, Senator Latz, I got one question. How many people have been convicted or even charged with this violation in Minnesota in the last 10 years?
Senator Latz.
Madam Chair, Senator Howe, I don't know. But if the approach to preventing crime is to beef up penalties and get tough on crime that way, here's your chance to do it. We know these auto sear devices are on the streets. We know that they are proliferating. What I have not brought in to testify are police officers who have responded to crime scenes where victims have been splayed out from firearms containing these auto sear devices. I'd ask for your support for this increase in criminal penalties.
Senator Howe.
Thank you, Madam Chair, and Senator Latz. You know, I'm not going to agree or disagree with whether they've been used on the streets. They probably have. My question is this does nothing to help us prosecute those folks, and that's what's lacking. We're not, you know, that's my problem is we have no one that I know of in the state that has been convicted or charged in recent memory of anything under this statute. So that's my concern. Thank you.
Senator Westland.
Very briefly, Madam Chair and Senator Latz, I'm having a little mental whiplash because we literally just heard on the prior bill that we should be increasing penalties for criminal behavior. My understanding is you aren't taking away anyone's Second Amendment right. You are increasing penalties in this bill for behavior that's already illegal. Is that accurate?
Senator Latz.
Madam Chair, Senator Westland, yes.
Senator Westland. Senator Limmer.
Thank you, Madam Chair. Just a question to Senator Latz. On our books now, possession or the operation of a machine gun or a trigger activator to convert a gun to a fully automatic is a 5-year sentence, and your bill wants to move it to 20. So could you give me a justification for the 20-year? It seems like we usually don't jump that far when we're making a difference in sentencing. We do it more in an incremental way, so why are we bumping it up 400% in a sentence like this?
Senator Latz.
Madam Chair, Senator Limmer, 2 reasons. One is, given the perniciousness of what's on the streets today, 5 years was way too low. It doesn't reflect today's situation. Secondly, if we go to 20 years, I'm pretty certain, I'm looking for the verification of this, that it will become a presumptive commit if there's a conviction. And we at least need to get up past that point for these auto sears, in my judgment.
Senator Limmer.
Senator Latz, the only concern I have on this is whether or not there's judges that are willing to make that sentence a reality, knowing that many of them in their past performance aren't even following our mandatory minimum requirements for the use of a gun in a crime. Thank you, Madam Chair.
Senator Carlson.
Thank you, Madam Chair. And, you know, stop me if you see me going off track here, but I do need to make some corrections and perhaps even some observations on one of the testifiers we had. I'm not sure. Well, first of all, I do not like the threats that we have had to sit here and sit through. I have had those from the Minnesota gun rights people. There is a video that blames me for San Bernardino, Fort Hood, Chattanooga, Orlando, 9/11, and other things. And that has been on YouTube for several years, blaming me, showing my family, showing me get sworn into this office, and saying that called Jim Carlson and displaying my phone numbers. I have gotten lots of threatening calls from that video. Now then, I have to say that there's another issue that goes in the background here, and that is Mr. Dorr said Minnesota gun rights, but we have a letter from the House of Representatives, signed by 16 representatives, most of them Republicans, that say, and I'll just read the last of it here, don't be fooled by the fake out-of-state Minnesota gun rights. They're not working with us, and they're not working for you. This came from the Minnesota House of Representatives because Mr. Dorr was centered in Iowa, not Minnesota. And I realize that he has now moved to Minnesota, but this is a truth that you need to consider when you hear all of the other things about his supporters in the background. He loves to embellish. He loves to threaten people. And this cannot be tolerated in the sentence. So thank you, Madam Chair, and I'll show you with my vote.
Thank you, Senator Carlson. Do we have any final comments about the actual bill? Okay, Senator Latz.
Madam Chair, just to amplify the answer to Senator Limmer's question, the fiscal note, which is included in our materials, indicate that if this is ranked, the Sentencing Guidelines Commission is assumed it will rank it as a severity level 8, where it's a presumptive commit.
Thank you.
Madam Chair, I move that Senate File 2827 be recommended to pass and be referred to the Committee on Finance.
Senator Latz moves that Senate File 2827 be recommended to pass and referred to the Committee on Finance. All those in favor say aye. Aye. Opposed? No. Motion's adopted. Senator Latz, on to Senate File 1117.
Madam Chair, I'm going to ask the committee's indulgence for a 3-minute break.
Okay, Senator Latz. We'll take a brief recess.
Thank you, Madam Chair.
1117.
Thank you, Madam Chair and members. I'm going to keep my opening remarks brief. We have a lot of people here who wish to share their thoughts. Senate File 1117 is the Extreme Risk Protective Order Bill. It creates a legal mechanism by which law enforcement and family members who are aware of a person that is distraught to the point where their conduct is indicating that they are a substantial danger or threat to themselves or others, to get a court order by a judge requiring that person give up the firearms they have in their possession, or that law enforcement be authorized to remove those firearms from that possession for the purpose of preventing suicide, homicide, injury, assaults by the use of the firearm. Currently, there is not a process for that unless the individual who possesses the firearm basically begins the act of committing a crime. And so law enforcement's hands are tied, and this is particularly traumatic when a family member calls and says, so-and-so is in this space, this place, having a great deal of difficulty. He's got a gun. We're afraid he's going to use it on himself or someone else. What can you do? So this gives a tool for that to happen. There are two pathways for this. One is by petition with an expedited process for a hearing at which the respondent or the subject of the protective order would have a right to be present before there is any order issued. And there's quite a detailed list of process that is contained in the bill in order for that to happen. Criteria, standards, there is an itemization there of the factors that the judge would consider. And there is a mechanism to ensure that law enforcement is notified and has the ability to participate in that proceeding, even if the petitioner is a family member. The other process is an emergency order. It would be ex parte, meaning it could happen immediately in front of a judge without the respondent or the proposed subject of the order being physically present to participate in it because it's necessary on an expedited basis. And then the higher standards for meeting that request for an order because the fear is that harm is imminent. And then there is also a specified process for a prompt post-order hearing at which the respondent would have the opportunity to participate and indicate that perhaps the order was not appropriate or not indicated, and then the judge would make a final decision for a longer term. I'm going to leave that basic framework right now and ask us to hear the testifiers.
Thank you. And just briefly, so we have the right bill in front of us, Senator Latz, you have a delete all amendment. Council has a few oral amendments, so I'll ask Mr. Backus to read those.
Madam Chair and members, the oral amendment is on page 13, and it is lines 13.10 to 13.12, delete the sentence beginning if the law enforcement agency does not receive. Currently, the bill was changed from the original version. It doesn't allow law enforcement to charge respondents for fees relating to store the firearm, and this provision wasn't deleted in the original amendment.
Thank you, Mr. Backus. Senator Latz moves the adoption of the A2 amendment with the oral amendment as described by council. This is an author's amendment. All those in favor say aye. Aye. The motion is adopted. And we have several testifiers. We'll start with Chief Henthorn. If you could state your full name and title again for the record as you begin your testimony.
Thank you, Madam Chair, members of the committee. My name is Jay Henthorn. I'm the Chief of Police for the City of Richfield. I'm here today speaking on behalf of the Minnesota Chiefs of Police Association, who represent the more than 300 police chiefs across the state of Minnesota and over 200 command staff officers working in departments across our state. I'm here this morning to testify in support of Senate File 1117. Extreme risk protection orders focus on the relatively rare, yet far too often tragic circumstances where an individual's mental health issues escalate to dangerous behavior. These orders will allow law enforcement or family members to bring evidence to a judge to temporarily separate the person in crisis from firearms when there is substantial evidence that they pose a significant danger to themselves or others by possessing that firearm. Family members and law enforcement are often the first to see the warning signs, and we believe the issuance of a temporary extreme risk protection order is a sensible and reasonable option to address these potential dangerous situations. We stand in support of Senate File 1117 and sincerely thank Senator Latz for bringing this bill forward. Thank you for allowing me to testify here this morning.
Thank you, Chief. Bob Small, if you could state your full name and title as you begin.
Thank you very much, Madam Chair, members. My name is Robert Small. I'm the Executive Director of the Minnesota County Attorneys Association. And John Choi, our Ramsey County Attorney, was going to testify, but he was called away, and I'm substituting for him. To let you know that our association would echo the comments of Chief Henthorn and would be in full support of Extreme Risk Protective Order, Senate File 1117, as amended. I would also like to thank Senator Latz. Senator Latz has been working with our association for many years on this bill, and we are pleased that it is where it is today. So thank you, Madam Chair and members. Thank you, Senator Latz.
Thank you, Mr. Small. Thank you, Chief Henthorn. I'll invite the next two testifiers up, Dr. Reese and Commissioner Jacobson.
Thanks, Chief.
When you're ready, state your full name and title for the record.
Thank you, Madam Chair and committee members. My name is Laurel Reese. I'm a family physician in St. Paul, and I'm testifying on behalf of the Minnesota Medical Association and the Minnesota Academy of Family Physicians, representing 10,000 physicians for the Minnesota Medical Association and 3,100 for the Minnesota Academy of Family Physicians, in strong support of SF 1117. This is a common sense measure to allow family members and law enforcement to petition courts to remove firearms from individuals who are displaying signs of risk to themselves or others. While much of the focus of firearm injuries has been on homicides, the untold story has been about suicides. Nationwide, the majority of gun deaths, 3 in 5, are due to suicide. Sadly, in Minnesota, 69% of firearm deaths are due to suicide. Studies exploring the links between laws and reduced rates of suicide make it clear that these laws work. Indiana's suicide rate declined by 7.5% when its extreme risk protection order law took effect. Connecticut's suicide rate declined by 14% when enforcement of its law increased. The research makes it clear these laws work to reduce suicide fatalities. Now, some are going to argue that people who are suicidal will just find alternate means to harm themselves, and that's not accurate. Suicides by firearms are dramatically more lethal than other means. According to the CDC, 87% of suicide attempts were fatal, compared to 3% of medication or drug overdoses. Suicide attempts involving firearms are 2.6 times more lethal than the next leading cause of suicide, suffocation. Suicide is often an impulsive decision. So removing firearms from the immediate vicinity is a potentially life-saving intervention. Extreme risk protection orders empower family and law enforcement to petition for an order that removes guns from a high-risk situation. On behalf of the state's physician community, we strongly urge your support for this important life-saving measure.
Thank you, Dr. Reese. And while you leave the table, I'll invite Melissa Kennedy to come forward. Commissioner Jacobson, state your full name and title for the record as you begin.
Thank you, Madam Chair, members of the committee. My name is Bob Jacobson. I am the Commissioner of the Department of Public Safety, and I am here today to support Senator Latz's Senate File 1117, which will put in place extreme risk protection orders in Minnesota. Extreme risk protection orders are another part of the governor's public safety budget. In many instances of violence, family members, friends, or local law enforcement have the ability to notice warning signs that a person close to them is at significant risk of harming themselves or others. This has been found even more true with those who commit suicide, mass shootings, and school shootings. It should surprise no one in this room that suicides are the leading cause of gun-related deaths in Minnesota. And while homicide levels have risen in the metro, nearly 60% of gun suicides happened in greater Minnesota in 2021. Much like background checks, this bill will not fix every issue or remove every gun from a dangerous situation, but it will certainly help. Senate File 1117 would give family, friends, and law enforcement a way to intervene before something truly terrible happens. DPS, through our Office of Justice Programs and the BCA, hear stories of crime victims who wish someone could have intervened. This bill has the ability to reduce the number of victims and the terrible but potentially avoidable acts in Minnesota. Firearm safety and common sense gun laws will help keep everyone in Minnesota safer. The Minnesota Department of Public Safety supports Senate File 1117. Thank you.
Thank you, Commissioner Jacobson. As you leave, Dick Davis, you may come forward. And Melissa Kennedy, when you're ready, please state your full name, title to begin your testimony.
Good morning, Madam Chair and members of the Senate Public Safety Committee. Thank you for having me here today to share my story. I am Melissa Kennedy, a family medicine provider. I have worked in this role for the past 20 years serving the communities of Wright County, Minnesota. And I am a gun violence survivor. I am here today to encourage you to support Senate File 1117. While I am here in my personal capacity, I want to note that my employer, Allina Health, and several other healthcare organizations in our state have pledged their ongoing commitment to ending gun violence and have urged legislators to take meaningful policy actions to eliminate gun violence in our communities. On the morning of Tuesday, February 9th, 2021, I went to work in our small community clinic in Buffalo, Minnesota. At approximately 10:50 a.m., while I was in an exam room with my patient, in unexpected shock and terror, gunfire echoed through the halls. Gregory Ulrich walked into our front lobby, pulled out a handgun, and started shooting at my colleagues. As he methodically walked through the clinic halls, we ran, we hid, and we waited. By 11 a.m., 5 members of our team had been brutally gunned down, and by the end of the day, my colleague, a nurse, and a beautiful young mother, Lindsay Overbay, was dead. This bill matters. Gregory Ulrich was well known to the Buffalo community, Buffalo Police Department, and our clinic. He was a disgruntled patient upset with his care. He had threatened to kill doctors and nurses and had violated a restraining order Allina had in place, a misdemeanor charge thrown out after he was deemed mentally incompetent to stand trial, and the charge vanished from his record. We knew he was dangerous, but Minnesota did not have a law to protect its citizens from people in crisis. Even after his interactions with law enforcement, he was able to obtain a legally issued permit to purchase a gun that he later used to take one life and forever changed the lives of so many others. February 9th, 2021 is forever etched in my memory. Since then, I've had days of grief and suffering and thankfully days of survival and hope. We have since reopened our clinic, and most of us who were there that day continue to show up, unwavering in our commitment to serve our community. Thank you for the opportunity to speak on this matter. Thank you for the work you do in serving the citizens of Minnesota. Recent polls show that an overwhelming majority support gun safety legislation. You have an opportunity and an obligation to protect and save lives. We are counting on you. Thank you.
Thank you, Ms. Kennedy. I'm very grateful that you're actually here with us today. I'm so sorry for the loss and the trauma that you experienced. Okay, as you leave the table, we'll invite Sue Abderholden up, and Dick Davis, you may begin. Please state your full name and title at the beginning of your testimony.
Thank you, Madam Chair and committee members. I'm Richard Davis, here on behalf of Giffords Gun Owners for Safety to testify in support of Senate File 1117, which would create an extreme risk protection order or red flag law. Extreme risk orders are important tools that law enforcement and family members can use to prevent violence. In many of the highest profile mass shootings in modern history, the shooter was in crisis. If family or law enforcement had possessed a tool to intervene and restrict their access to guns, dozens of lives could have been saved. In California, extreme risk orders have been used to prevent mass shootings in 21 cases. Extreme risk protection orders are an effective way to prevent gun suicides. In 2021, the most recent year for which CDC data is available, 406 Minnesotans died by firearm suicide, 71% of all gun deaths in the state. Suicide is often an impulsive act, and if we can keep a gun away from a person at that moment, we can save their life. Nearly all people who survive a suicide attempt don't try it again. Extreme risk laws can keep firearms away from people at risk while they get the help they need. As a Minnesota gun owner, I support this bill. It does not infringe on my rights or those of other gun owners. When an extreme risk petition is filed against someone, they have a right to appeal it, and there are serious criminal penalties for its misuse. According to the 19 other states and the District of Columbia that have laws in place, they're being used to save lives. I strongly urge you to pass Senate File 1117 out of committee. Thank you.
Thank you, Mr. Davis. As you leave, I'll invite Sammy Rahameen up to the testifier table. Sue Abderholden, you may begin. State your full name and title for the record.
Thank you, Madam Chair. Members, Sue Abderholden, Executive Director of NAMI Minnesota and Co-Chair of the Mental Health Legislative Network, a coalition of over 40 mental health organizations. In 2021, 808 people died by suicide in Minnesota. That's 107 people increase from the year before. Men made up about 80% of those suicides, and in 2020, there were 513 firearm-related deaths, and 69% were suicides. We want to prevent these deaths, and one strategy in suicide prevention is called means restriction. This is when we restrict access to lethal means to prevent someone from taking their own life. Time is key to preventing suicide, to help them see the crisis won't last, and to connect them with someone who can help, which is why limiting access to lethal means is so important. We appreciate the amendments that were adopted today because we're really not talking about harm to self, a term used in the Commitment Act, or bodily harm, a term used in the criminal statutes. We are talking about suicide, and we need to just say that. Again, we are talking about people who may be deeply depressed, who have lost hope, and are at risk of taking their own life. 72-hour holds don't really work in this situation because we have to wait until it's imminent risk. And what we know about suicides is that 75% of people who attempt suicide, the time between when they were thinking about it and then they made the decision and then they attempted, so the time between the decision and attempt, 75% is less than an hour. 25% is less than 5 minutes. And so we can't wait until it's imminent. We have to intervene far earlier than that. I just also want to add that suicide is a health issue, and so those records shouldn't be public. They should really be kept private because no one else needs to know. And finally, I just want to say, because we are talking about suicide during this hearing, if anyone is listening and is thinking about taking their own life, I would encourage them to call 988. Thank you.
Thank you so much. As you leave the table, we'll invite Gretchen Damon to come forward, and Sammy Rahameen, if you could start by stating your full name and title for the record.
Thank you, Madam Chair and members. My name is Sammy Rahameen, and I'm here on behalf of Jewish Community Relations Council of Minnesota and the Dakotas. It's been 10 years since my father, Reuven Rahameen, of blessed memory, was murdered at my family's company, Accent Signage. 5 other fathers were taken from their families and their communities that day as well. I miss my father every day. He was creative, compassionate, and persistent. An Israeli immigrant to Minnesota, he started his business in his basement and grew it to a celebrated international stature. He was generous to his family and community. I am proud to be his son. I believe he would be proud of me for working at JCRC, where our mission includes working to safeguard the Jewish community. This bill would help us do that. Jewish Americans experience gun violence both as the targets of anti-Semitic attacks and everyday citizens maimed and killed by this uniquely American crisis. Just recently, a person visited a local synagogue before sending threatening emails to the rabbi. Our investigation led us to believe that this person possesses firearms. However, under current law, until the person commits a crime, our options to intervene proactively are limited. This bill would allow our law enforcement partners to petition to remove the firearm from the person who we believe poses a significant danger to our community. As Jews, we are also concerned for the safety and well-being of all Minnesotans and believe this bill would offer a necessary tool to mitigate incidents of gun violence, including suicide. On behalf of my family and the JCRC, I ask you to please vote in favor of this bill. Thank you.
Thank you, Mr. Rahameen. I just want to say I'm so sorry for your loss and really appreciate you sharing your story with us today. Gretchen Damon, you may begin, and I will invite Megan Walsh to come forward to the testifier table as you start.
Madam Chair and members, my name is Gretchen Damon, and I am here on behalf of Moms Demand Action for Gun Sense. Extreme risk laws can save lives by creating a way for family members and law enforcement to act before warning signs escalate into tragedies. On a dairy farm in northern Minnesota, a father raised his family. He was a community leader and lifelong sportsman. Later in life, he was diagnosed with a type of dementia leading to changes in his personality. He became paranoid and hostile. Because there were guns in the home, his 2 adult daughters were constantly frightened about what could happen. Eventually, they were able to secure the guns with the advice of the sheriff's department. Nevertheless, the officers were also clear about the limits of what they could do to help. Extreme risk protection orders offer families like this one a safer and more immediate way out of a stressful and potentially dangerous situation. This bill would make it feasible to petition a court of law for an order to temporarily prohibit access to firearms. It is carefully written to include robust due process protections. Several years ago in St. Paul, a loving husband and father suffered a back injury. He became addicted to pain medication. His behavior changed drastically, becoming abusive. His wife acquired a restraining order, changed the locks, and moved out of the home with their 5 children. She returned a few weeks later for supplies. Her husband entered the house through the automatic garage door. She called the police. Just as they arrived, she stepped out of her front door, and her husband came up from behind and shot and killed her. The restraining order was not enough. Firearms needed to be absent from this dangerous situation. We think tragedies like these happen to other families, not ours. The family in northern Minnesota and in St. Paul did not foresee these predicaments. When Minnesotans discover a loved one in crisis and firearms are
Please wrap
accessible,
up your testimony.
they need a vehicle toward safety. Please vote yes on this bill.
Thank you. As you leave, I'll invite Leah Condis to come forward. Hopefully I'll pronounce your name correctly. And Megan Walsh, you may begin. State your full name and title for the record.
Thank you, Madam Chair, committee members. My name is Megan Walsh. I'm the director of the Gun Violence Prevention Legal Clinic at the University of Minnesota Law School. There, I work with law students and the Minnesota Attorney General's office to defend Minnesota's gun laws against constitutional challenges. My teaching and research is specifically in the Second Amendment. However, I'm here today in my personal capacity. I speak only my views. Oftentimes, we hear a debate over these extreme risk protection order due process protections, but courts have nearly uniformly come out with the voice that these protections are constitutional. Courts across the country have held extreme risk protection orders to be constitutional, both under due process challenges as well as under Second Amendment challenges, including most recently on March 1st, where a New York court held, according with the New York Rifle and Pistol Association versus Bruin decision, to be constitutional, and found that New York state law allowed the government to disarm an individual who was suicidal, using very similar provisions to the ones at issue here today. The Supreme Court has found these due process procedures to be constitutional in multiple other areas, including pre-hearing deprivation of rights, ex parte, including situations where children are removed from the custody of their parents without giving notice or a hearing to the parent in exigent circumstances where the child's safety is at risk. Certainly, the same is true for disarming an individual who is a threat to themselves or others, has been found to do so by a court. This law is constitutional, and so you can vote for it, but you should vote for it because it will save lives. In 1983, a man was able to smuggle a firearm into a courthouse in Chicago. He had been under suspension from his role as a police officer. He had a number of previous physical altercations, and his lawyer requested to be withdrawn from his case because of his client's behavior. He went into court that day in a situation of crisis, in an emotional situation, litigation with his ex-wife. He shot the judge of the case. He shot my friend Jim Pizor, who is representing his ex-wife. That day, my dad lost his best friend, and my best friend lost her dad. Jim was the kind of guy, he used to sleep on the floor next to Rachel's crib because he couldn't bear to hear her cry. She's gone 40 years now without him. You have the opportunity to prevent these crimes. This bill allows you to do that. The Constitution allows you to make this policy choice. I ask that you do so today.
Thank you, Ms. Walsh, and again, my sympathies for your loss. Leah Condis.
Madam Chair and members, my name is Leah Condis, and I am here on behalf of Moms Demand Action for Gun Sense in America. Wyatt Day was a kind, gentle young man with a great personality, but when he was only 21 years young, he died by suicide, leaving behind a 1-year-old son. Before his death, Wyatt struggled with chronic pain and behavioral health issues. His father, John, my husband's cousin, is a hunter and gun owner. Concerned about his only son's mental health, John got his guns out of the house. But when Wyatt bought his own gun, there was nothing his father could do. John knew that Wyatt posed a significant danger to himself, but was helpless to stop it. Please support Senate File 1117. Extreme risk protection orders are an important tool in the fight against firearm suicide. In Minnesota, 73% of gun deaths are suicides. Every year, an average of 363 people in Minnesota die by gun suicides. Suicidal crises are often short-lived, and a majority of people who attempt but do not complete suicide do not go on to die by suicide. But access to a firearm during suicidal crises greatly diminishes the opportunity for a second chance. 19 states and D.C. have enacted extreme risk protection laws, and evidence shows extreme risk laws can help prevent firearm suicides. Reducing a suicidal person's access to firearms can help save their life. Access to a firearm triples the risk of dying by suicide. Please help Minnesotans save lives by creating a way to act before warning signs escalate into tragedies. Thank you.
Thank you, Ms. Condis, and sorry for your family's loss. We're going to move to virtual testifiers. Maggie Salmon, you can unmute. Please state your full name and title for the record as you begin your testimony.
Thank you, Madam Chair and members. My name is Maggie Salmon, and I'm here on behalf of Students Demand Action in support of SF 1117. Myself and many in my community are fervent supporters of extreme risk protection orders. I'm lucky to live in a community that's had little to no issues with gun violence, but there's always a what if, accompanied by feelings of helplessness and insecurity. What would I do if someone I know had a gun but shouldn't? More importantly, would anything that could be done be effective? For example, most of us can recall the last time we watched the news after a mass shooting, and the days afterwards detail the perpetrator's motives. Documented warning signs are more often than not displayed, commonly over extended periods of time. A lot of these signs are reported, but little to nothing can be done. This is our system's major blind spot. We talk big game about preventing acts of violence before they occur, but what measures are currently in place to do this? This doesn't have to feel impossible. 19 states, including DC, have enacted red flag laws. They're an effective way to intervene before gun violence, like suicide or mass shootings, take more lives. ERPOs will lift a burden off of Minnesotans. Fighting for safety and security will no longer feel like screaming at a wall. Most of us are disillusioned by growing amounts of avoidable violence. In Minnesota alone, gun deaths increased by 44% between 2012 and 2021. Everywhere, we feel unsafe, increasingly unsafe, in malls, theaters, places of worship, and our schools. ERPOs give people a voice, placing the power back into the hands of the people and communities who have put up with this for far too long. They allow us to feel safer in schools, and we know that in the past, ERPOs could have saved lives in school shootings. For example, the shooter in the Parkland tragedy was reported to law enforcement on multiple occasions as he repeatedly displayed threatening behavior prior to the shooting, but without ERPOs in place, no action could be taken. Just last year in one of our neighboring states, Missouri, the family of the shooter at the Central Visual Performing Arts tragedy called to have the gun confiscated from their home prior, but the police couldn't do anything without an ERPO law. We don't deserve to have our lives put at risk when preventative measures can be put in place. And frankly, students like me shouldn't have to convince adults to protect us from gun violence. So please, show us you agree and support ERPOs. Thank you.
Thank you for your testimony. Next, we'll go to Kelly Roscom. You can unmute and begin your testimony by stating your full name and title.
Thank you, Madam Chair and members of the committee. My name is Kelly Roscom. I'm the Director of Law and Policy at the Johns Hopkins University Center for Gun Violence Solutions, though I'm here today in my personal capacity as a person who was born and raised in Minnesota and still has a great deal of love for the state and its citizens. There is an ever-growing body of research that suggests that ERPO laws are valuable tools to prevent all kinds of gun violence. One peer-reviewed study of Connecticut's ERPO determined that for every 10 to 20 orders issued, at least one suicide was prevented. Another study of Indiana's ERPO law determined that for every 10 orders, one suicide was prevented. A third study estimated that Indiana's law was associated with a 7.5% reduction in firearm suicides, while Connecticut's law was associated with a 13.7% reduction in firearm suicides. In addition, this is also a promising tool in the prevention of mass shootings. One study analyzed 6,800 cases across 6 states that have ERPO laws and found that almost 10% of cases involve threats of mass shootings, the most common against K through 12 schools and businesses. This is a tool that can definitely save lives, and I urge you to support SF 1117. This is also a law that comports with constitutional provisions. As you heard, this bill contains all the necessary due process, including a decision made by a judicial officer, meeting a legal standard of proof. There is a prompt post-deprivation due process hearing, and it involves the immediate and present danger of irreparable harm caused by firearms. The recent Supreme Court decision in Bruin is also no impediment to the constitutionality of this law under the Second Amendment. There, the court said that laws that are relevantly similar to historical laws are perfectly fine under the Second Amendment. There is a long and storied tradition in the United States of disarming people who are dangerous. This bill is exactly that. It targets individuals who are a danger to themselves or to others, and I strongly urge you to support it. Thank you so much.
Thank you, Ms. Roscom. Next, we'll hear from Ramya Swamy. Unmute and begin your testimony by stating your full name and title for the record.
Thank you, Madam Chair and committee members. My name is Ramya Swamy, and I'm the State Policy Manager for the Brady Campaign to Prevent Gun Violence. Extreme risk protection orders like the one proposed in Senate File 1117 are an effective and importantly constitutional way to prevent homicide, mass shootings, and especially suicide. Contrary to popular belief, gun suicide is preventable. Yet, according to CDC data, over 75% of the Minnesotans killed by gun violence between 2015 and 2020 died by suicide. That's why this ERPO bill is so important, because ERPOs are one of the most effective measures to prevent gun suicide. For example, researchers associated Connecticut's ERPO law with a 14% reduction in gun suicide and associated Indiana's with a 7.5% reduction. This law could be the difference between Minnesotan families gathering for a funeral or for a celebration. To be clear, the ERPO bill neither violates Second Amendment right to keep and bear arms nor the Fifth and 14th Amendment right to due process. First, this ERPO bill mirrors historical laws that place firearm restrictions on people who were understood to present a safety risk. In this way, the ERPO bill satisfies the Supreme Court's requirement that a modern firearm regulation consists with the Second Amendment's text and historical understanding. Second, the Supreme Court has been quite clear that the right to keep and bear arms is not unlimited. For example, Justice Kavanaugh, concurring in Bruin, wrote that, properly interpreted, the Second Amendment allows a variety of gun regulations. That's why 19 states and the District of Columbia have ERPO laws like the one proposed here that no court has overturned. Indeed, courts have found that ERPOs, being temporary and tailored for proven risk, are permissible so long as they include sufficient process, which this bill does. Though due process generally requires the state to give notice and an opportunity to be heard before taking property, there are exceptions in cases of imminent danger. The ERPO bill proposed here is constitutional in both scenarios. The bill requires the state to give notice and a hearing before issuing an ERPO when there is not imminent danger. And when there is imminent danger, the court may issue an ERPO first, but then it must quickly provide a notice and set a hearing. On top of all this, ERPOs are not capricious. A court cannot issue an ERPO unless a preponderance of the evidence supports one. And anyone subject to an ERPO may request to regain their firearms anytime within the year that the ERPO is operative. In this way, the ERPO bill provides notice and an opportunity to be heard and complies with due process. The sad, inevitable fact is that no one is exempt from rough times.
Please wrap up your testimony, Ms. Swamy.
Thank you. It's as simple as that, all of the reasons stated above. So for those reasons, I urge you to pass this bill. Thank you.
Thank you for your testimony. Okay, we'll move back to in-person testifiers. I'll invite Ben Dorr and Brian Gosh. Before you begin, Mr. Dorr, we do have your letter. Generally speaking, we hope to hear things other than what we can see in writing before us. I will ask everyone to please let you get through your testimony in the 2 minutes provided, and hope that you will provide some comments to the bill. Go ahead.
Madam Chairwoman, members of the committee, I'm Ben Dorr, Executive Director for Minnesota Gun Rights. There's not a whole lot you can say to get in depth on garbage legislation like red flag laws in 120 seconds. And we do consider it that bad. It's unhelpful, it's unconstitutional, it won't save lives. What it has done is cost one man his life in Maryland when the police knocked on his door at 4 o'clock in the morning because his ex-wife got an ERPO on him. He didn't know what was going on. He got shot and killed because the police were put in that awful situation. We have 72-hour holds on the books. What this stuff will do will allow angry ex-spouses, ex-boyfriends, ex-girlfriends, neighbors to have people's firearms confiscated. It is unconstitutional, and Minnesota Gun Rights would like it voted against. Is that acceptable? So we would like this to be voted no. Our members, we don't forget votes like this. It's very important to us that we get these things on record and we'll tell gun owners what happened at election time. And I guess if I have any time left, I'm just curious if I can respond to Senator Carlson and the litany of personal attacks, very strange on a member of the public. Can I address any of that, or?
Mr. Dorr, I'll ask you to keep your comments to the bill as I'm asking our members to keep our comments to the bill. And I know things have gotten heated here. Hope we can all take a deep breath and keep our focus on the bill in front of us.
Good. Well, maybe I can have a chat with you afterwards, Senator. I'd appreciate that. So that is all. We don't like red flag laws. We'd like you to vote against them. They don't save lives. They take away people's guns. Minnesota Gun Rights is opposed, and thank you so much for your time.
Thank you, Mr. Dorr. Mr. Gosh.
Thank you, Madam Chair, members of the Senate Judiciary Committee. My name is Brian Gosh, State Director for the National Rifle Association. Typically, before you have property taken away from you, you get the right to a hearing, you get to appear, you get to make your case. In this case, it allows for an ex parte hearing, which the respondent can't be at. And then you could possibly have your property taken away. And it can be done with relatively low standards of proof. So the bill as drafted said reasonable grounds. That's a really low standard to prove. Now, the A2 amendment offered by Senator Latz raises that to probable cause, but it's also a low standard to prove. Senate File 1117 only confiscates firearms, so it truly is just a gun-grabbing piece of legislation. It doesn't take any knives, rope, poisons, vehicles, explosives, any other type of items that people could use to hurt themselves or other people. Moreover, there's nothing in the bill that requires mental health treatment or even a mental health evaluation for the individual who is losing their property. Once the firearms are confiscated, there's no obligation that they be transported or stored properly or by the least restrictive means. For example, in existing statutes under domestic abuse statutes 518B, if there's an order there for removal of firearms, you get 3 days to transfer those to a friend who doesn't live with you. In this case, this bill, you only get 24 hours. It has to be to an FFL or an LEA. So existing statutes give you 3 days and you can transfer it to a friend. This does not allow for that. The existing civil commitment statutes found at 253B truly are the better process, in my opinion, to help someone who is has a mental health concern and might hurt themselves or other people. And in that case, it's better because you're removing the person from the house, from all dangerous objects, and you're putting them on a hold where they're evaluated by a mental health professional, and then they can, through that process, then get mental health treatment, even including forced medication. One final comment, the state of Colorado has both universal background checks and red flag laws, and those did not stop the school shooting yesterday. So I would suggest that looking to tackle the problem, this piece of legislation will not likely do that. Thank you, Madam Chair.
Thank you, Mr. Gosch. I'll invite Carl Kaufman and Rob Dorr to the testifier table. When you're ready, Mr. Kaufman, please state your full name and title for the record.
First of all, I feel like I've been here before. Madam Chair and members, my name is Carl Kaufman, and I'm here today on behalf of the NRA. I'm a lifetime member of the NRA, a youth hunter safety instructor, a registered range safety officer, and I'm on the board for our local Wilmer Rifle and Pistol Club representing 500 members. I am here to state my opposition to the red flag law. I think there is a lot of area there that can be misused. Again, I have no issue with people being diagnosed mentally ill and they need help. And if they need to be removed from their property, I think that is a good process to pursue. I think this is an infringement on due process. As stated earlier, I have great concern about people using it as a retaliatory or a weaponized approach to people within a neighborhood or within a relationship. It also constitutes a registration, because when those guns are removed, they're going to be registered. 3 things, I've said it before today, I will say it again. Enforce, prosecute, and sentence. These are things that need to be done throughout the system in firearm ownership. And I think it gets abused. It's not pursued enough in terms of applying the laws and the sentences. Thank you very much. I appreciate the opportunity today.
Thank you, Mr. Kaufman. Mr. Dorr, state your full name and title again for the record.
Rob Dorr. I am the Vice President of the Minnesota Gun Owners Caucus. Madam Chair, members of the committee, Senator Latz, I would love to be the opportunity to get into an elongated constitutional debate on this topic, but unfortunately 2 minutes would not permit that. Likewise, a debate of statistics. I did just send to each of the members and to Ms. Kaplan as well some data from the CDC showing suicide rates in states that have passed red flag laws. And the data shows that there has been no reduction in suicide rates among states that have passed red flag laws. In fact, the only state that has had a reduction in suicide rates at all, Nevada, saw a 20-year decline in their suicide rates prior to passing their red flag law in 2019. And that was part of a comprehensive mental health campaign from the state to reduce Nevada from one of the highest states of suffering mental illness and suicide down to, they're at least out of the top 10 now, which they're particularly proud of. I wanted to appeal to your logic and emotions a little bit. A couple years ago, we had one of our members call me up. Their question was rather simple. Is Rob, I'm a veteran. If I go and I get mental health care, will I lose my gun rights? And I could have given him the answer is no, probably not unless you're committed to a facility. That would have been the right answer, but I was actually more concerned about the individual himself and started talking to him. And he had just been divorced a couple years prior. He had a child that he lost to opioid overdose the year prior, and he felt like he was really struggling. And he wanted to seek mental health care, but he was so concerned about the prospect of losing his Second Amendment rights, his right to hunt and trap shoot. He was an avid trap shooter, that he was concerned about that being a barrier to being able to seek mental health care. This bill, this amendment that was just added, adds mental health professionals as individuals who can seek red flag orders. I cannot think of a larger barrier of concern for law-abiding gun owners to seek mental health care that they might need than the prospect that their therapist or their counselor may be able to use their that ability to get a red flag order against them. It'll have a chilling
Please wrap
effect.
up your testimony, Mr. Dorr.
Thank you. It'll have a chilling effect on people's willingness to seek mental health care, which they need, particularly veterans. Thank you.
I don't believe Reverend Christopher is still here with us, but we are going to need to take a brief recess. We do have floor session, so we'll do that. And the Senate is under call, so we will do that and come back. Committee's in recess.